Good morning. Good morning, 13 jurors. Good morning. Hello, hello. Happy Thursday. Happy Thursday. I'm still not awake yet. Hello, hello. We all wake up together. Okay, real quick. We have our first in tailgate who was probably here before I was, honestly. We started a little bit later today because they're not starting till 9, but we've got eyes on the courtroom. Let's see, our first, we have a new way to give away all of your fake furniture. So this is the voyage run of this way of giving away your fake furniture, but here's our first in tailgates. That's really funny. It's funny that you say JT's a genius because y'all automatically know that wouldn't have been me that could put that together, that it had to be Brother Brewmeister. All right, so we will go ahead and yes. Sorry. Mom's offering snacks again. We're going to go ahead and go in and see what we got going on. Move me. We got 2 more minutes. Good morning. I see people still filing in. Good morning. Good morning. Good morning. Did y'all see where we yeah. Yep. I was just about to say, did JT wear the wig because of the 600 likes? Yep. It was worth staying on the extra 3 or 4 minutes to make sure we got there. It was funny. Good morning. Good morning. Hello. Hello. Welcome. Good morning. I love it when everybody comes in and is like, good morning, like we really are reporting for jury duty. Lucy, here's my mom. So she's staring at the door like, I hear her in the kitchen. I bet she's going to bring me a treat. She just got a pup cup. My mom brought me coffee with, it's really good with like whipped cream in it. And she brought Lucy a little container with whipped cream for her pup cup. It's hilarious. That dog is spoiled. Let's see. It is a weird, oh, where'd it go? Everything moved. Lady in Gray, it is a weird setup for a courtroom. I haven't seen that kind of setup. It's a little interesting. I love coffee and whipped cream too. Yeah, my mom is awesome. And then she's peeked her head in here. She's like, do you want a grilled cheese? It's like, yes. I can kind of hear that they have a mic, but not enough for a hot mic moment. Can barely hear it. So y'all know how we were talking about what was going on in the courtroom. The person who I'm following, I gave you all his name yesterday, but he's doing the live tweets from there. It's Bryson Boom Paul, and his Twitter handle is at Bryson BRYSON Boom Paul. But he's the one who oh, that's so funny. He's got stuff on here. Let's see. So 4 minutes ago, he tweeted that Melly's female legal counsel was just asked by a legal intern who she was, and she replied with a smile, "I'm the boss." It's funny. Is she wearing that same color again? That must be her favorite. Let's see what else. Kevin Lyles at 300 and Kevin Lyles are scheduled to be in attendance and sitting in Melly's gallery for day 4. I think that's all from this morning. Yeah, that's all from this morning. So he's the one I've been following on Twitter. What does my mom think of my job? She thinks that she doesn't like me doing days because she likes to be able to go have lunch. But other than that, she loves it. I don't know where Melly's at. I haven't seen him yet. There was, so I've seen a lot of y'all in chat saying this, and there's been a lot of people on Twitter and everything talking about this. There was a video that Law and Crime took yesterday, a screen like recording of those last moments. When we were hanging out last night right before we finished, or yesterday afternoon, and I was like, I wish I knew what he said, because he was talking to her and he was getting real animated with his conversation and stuff. There's a part that was right before that I missed, and she's literally like leaned all the way over. It looks like she's sniffing him. It looks like she's maybe trying to read something, but it comes across as it looking like she's sniffing him the way that the video was. It was really funny. Good morning. Good morning. I have not heard anything else about the hallway incident from yesterday. I could not find anything, and he didn't tweet anything else. The only thing he tweeted was a correction to the way that he said it. When I got caught up reading it, I was like, whoever came in pounded on his twice, and he fixed it to chest. I was wondering what he was pounding on. I assumed that, but that's what he said. He pounded on his chest twice and looked at Melly and all that, and then they never did post anything else about it. So I don't know. I tried. Oh, our sidebar counter is here. Welcome, welcome. Welcome. Try to think what else they were saying yesterday, that they had I just got distracted with making sure that okay, there's another one he just tweeted. Melly signed with Kevin Lyles at 300 in 2018 in a joint deal with Atlantic Records. That's the newest tweet. But y'all follow him if you want to. I can't always read it when they come out right away because I don't want to talk over everything. Okie dokie, let's see. What? Come here. Come here. That's what it looked like to me, and apparently to a lot of other people. Let's see. Good morning. Good morning. I guess they're running. Why are you whining? What? You want to go say hi? You want to go say hi? Say hi. You need a bath. Oh, goodness. Lucy's wanting my attention. The Twitter reporter, it was making sure I spell it right. Yeah, Bryson with an O. Bryson. Boom. Paul. I want to remind everybody our chat is kind to each other. So any of the nonsense will be removed. So yeah, Lucy is the I see you have a bunch of people excited to see you this morning. Lucy's our little mascot. I hear the mics coming. Okay, so here's the next tweet. Kind of gives us an idea of what they're doing. We don't have audio. So he says the prosecution reviews planned Snapchat evidence photos with the Melly lead defense, David A. Howard, before day 4. So they're reviewing the planned Snapchat evidence. I'll be glad to be back in my chair tomorrow because this one's hard to lean over. Judge needs to give us more stretch breaks. Good morning. I see everybody filing in. Good morning. Yeah, this is gonna be a long one. I think they had on the docket, they had scheduled until August 2nd. All right, he tweeted again. He said, Sack Chaser's mother enters the courtroom, but immediately exits, saying, I need to catch my breath for a minute. I feel bad. I know families are having a hard time. I've got notifications on this if we hear. Anything else of what's going in there.
Tried your grilled cheese for a dog.
Thank you.
Come
Go. Go ahead. Lucy's going to go play with her dogs. We're waiting on them. I guess they're reviewing Snapchat evidence that they're going to be bringing in. From what I hear, and we're waiting on them to bring Melly in. Yeah, she came in and she really brought me a grilled cheese. They have it scheduled through August 2nd or 3rd, but they said yesterday, from what I read, that they think that I think prosecution said that they would be done with their witnesses on the 10th, and then they said defense would be done with theirs around the 19th of July. So that's how long it's expected to go as of now. Of course, that can always, change. Sometimes quicker, sometimes longer, but that's the plan. I think this one's going to take a long time because there's so many technical parts to it, or technology parts to it. Like, so, when they do all of the different phone information, they have phone information they have to go through for a lot of them. And that's going to be time consuming. If y'all remember how long for those of you who watched like the Murdaugh trial, remember how long it took to go over all the phone evidence and all the, data moments of the phone and all that. Like, that's a lengthy process to get in. And we have phone evidence for like 4 or 5 of them that we have to go through. So it takes a while. Let's see. Mary, I hope not. I'm expecting it. The only Snapchat evidence I can remember seeing is the when we did the Snapchat in Murdaugh, and they had the foundation witness come in and basically say, this is how we record it, and yes, this is accurate, and this is how we know it's accurate, and that type of thing. It didn't take too long, but Lord knows, after hearing some of the stuff yesterday, I don't know how long some of this is going to take. I knew, like, the gun stuff is always going to take a long time because you have to go through all of the mechanics of guns and everything, like explain how bullets work and all. Like, it's so tedious. I get that, but some of them, I'm hoping it's just like, quick, get it in there, and let's be done with it. Not explaining like the history of bullets, but that stuff is necessary. Let's see. Yeah, the Murdaugh trial was brutal on establishing foundation and background on evidence, but that's why you know what? That's why you never see that part in a like a law and crime or a movie where the court scene's like the grand finale. Nobody puts the foundational experts or foundational witnesses in for those because they're not exciting. Good morning. Good morning. Hello, Abe. Hello. Hello, Virginia. Hello. I feel like they need to text me and tell me when they're going to be late, because then this is like an extra 15 minutes of sleep that I could have had. Good morning. Yeah, we were talking about the marble and the clash of the light paneled wood. I was saying I think the marble, his whole thing reminds me of like one of the 90s garden tubs. Oh, now they're saying that this will go until August, apparently. Well, that's what, okay, the tweet says, they told the Sheriff Castillo told the legal intern that the Melly double murder trial is expected to commence until August now. So maybe it is going to go to August. We'll be here. We live here now. This is where we are. It's going to get tricky if it's still going when show business starts. Because if that's the case, I'm not going to sleep much. I already don't sleep much. I'm not going to sleep much at all with them. And they were saying yesterday how cold it is in the courtroom too, that the jurors came back with like big jackets on and cups of coffee and stuff. And he said that at one point Melly was cold and he was like rocking back and forth. Apparently it's freezing in the courtroom. Let's see. The show business. She's a special kind of something. It's a spicy one. Well, I don't want to get it. It's too early to talk about what all she did. She's a hot mess, but that one I'm going to cover. So we'll get into that one. It's a doozy. Let's see. Yeah, I don't know how it's so cold in there because it's hot down here. It's hot in Florida right now. Hi, big girl. Let's see. This did Vanderlyn have another innocent victim locked up? Yeah. Heidi posted it yesterday, and I retweeted it with some of the information. But there was a firearms report that exonerated him, and she held on to it for over a year. This is in Florida. Nothing's going to happen to Dominique. They're not charging her with anything. They just let her go.
We're off Monday. It's a holiday. Then we're off.
You drunk?
No, that's okay. I'd like to extend that holiday to Tuesday and Wednesday. Can we vote on that, Judge?
You did.
Will the vote count? It's more important.
I know what votes you get. Thank you.
I want to make sure. Fair enough. I wish I could make a partial approval.
Can't reverse it.
You know, Kevin.
I missed something funny. Yeah, there's a lot of the closed caption tweets. People were screenshotting some of the stuff yesterday. Closed caption was on a roll.
Don't jinx it.
All right, let's go on the record, please. The state of Florida versus Denman, president, defendant, his counsel, and the assistant state attorney, the jury's in the jury room. Is there something you want to discuss, counsel?
Yes, Your Honor, I think there's a bunch of stuff we probably discussed.
Can we first approach?
Sure.
Hit it, go with the white noise.
Let me try anything?
That's awful. Let's see. I saw some questions. Everything moved, and now I'm trying to find it. Let's see. Dang, I lost it. So I guess Kevin Lyles is there now. The newest tweet says that Melly smiled and head nodded in his direction as Lyles sits in the front row.
Gentleman in front of us, he was the lead.
Portland's trial's in October.
We're checking the jury circulation.
I thought there was other issues that I just wanted to address.
There are.
Sorry?
There.
I'm just bringing the jury in, so tell me what your
No,
other issue is.
ready to.
No, tell me what the issue is.
The issue is we got presented this morning with a host of chat downloads that were purportedly downloaded from the chat account of whom the state reports to be Mr. Dumont's chat account. Before she introduces any statements, I think she needs to establish the relevance. This is just a download of a series of conversations. And putting them in en masse is a problem. Putting them in individually would require her to establish the relevance of the particular statement she seeks to introduce before introducing it. Our initial review of the contents that she wants to introduce shows relevancy problems, shows authentication problems, and shows prejudice and hearsay problems. So that's what we wanted to address with the court. We have a copy of what we're presented with here, and maybe we could present it to the court so you can take a look.
I haven't seen it take a look at it. When do you anticipate presenting it?
Shortly after the first witness, but so it's a business record on that. This is, and just so it's clear, this was provided as the initial discovery exhibit that was presented to defense counsel at the initial first ever discovery filing, and that was sent, you give me the exact date on that, but I believe that was approximately March of 2019.
So let me ask you this. I haven't seen it. How many exhibits are there? How many are How many are there?
This one is not particularly voluminous. There's a handful of pages, and then there are some video clips and some images. With regards to the images, I brought that to defense counsel's attention because there is one image that is on the defendant's Snapchat account that references some of the more inflammatory song titles. So I was going to tell them I'd be happy to hide that file so that the jury would not be able to access that or see that.
Okay.
And so I can provide those to your honor in the printout.
Sure, has it been marked for identification?
It has not yet.
So why don't we have it marked for identification? And is it possible that you do this or introduce these after lunch so we have a chance to look at them?
No, your honor. That's not for time frame on that. Like I said, I indicated yesterday due to one of the witnesses having COVID, we'd probably have to end early this afternoon, and I beg your indulgence on the time and scheduling on that.
So, there's an objection, I need to review it and see what it says, so after, who's the next witness? Yeah.
Tara Kelso, the RJ Lee.
So we'll talk about it after, just have it marked as an exhibit, and if you could, just give a copy to Travis after it's been marked, and I'll see if I can take a look at it as we're going, all right?
Understood.
But you said there's videos as well?
Yes, your honor. So there are
You're
videos.
objecting to these videos?
On relevant grounds and authentication.
When we take a break, I'll look, you just play it, we'll see what they're doing.
They're relatively short on the videos, so.
All right? You were indicating that these social media are all from the defendant's account or something like that? Where are they from?
These are from the defendant's Snapchat account, your honor. And so I'll have it marked as states J for identification purposes. Presenting to Travis a copy of the business records, authentication and certification, a copy of the printout of the chat records that are in a table format. Everything is contained on a USB. I'm also presenting a printout of all of the photos that were associated with the account, as well as a copy of with the photo that could be potentially an issue on the name of the songs taken out, and a copy of printout of the first part of the initial clip or the initial frame of every one of the videos on there.
And you intend to play all of these videos to the jury?
Yes, your honor, because the defense is contesting whose account that is and whose phone was using this, so that's the state's initial relevance argument.
Thank you. And it's all the same Snapchat account?
It is.
Thank you.
Your Honor, as an initial, just so that you know, a Snapchat account, I'm not sure how familiar you are with social media, but a Snapchat account does not identify a device because it can be accessed from your computer. So I don't think that would be relevant to demonstrate.
Thank you. Let's bring the jury in.
Okay, so they're wanting to show his Snapchat stuff to show that it is his account. It is. He is the one doing it, making the videos. He's the one controlling the account. They're trying to make sure that that's undisputed. I think defense is saying anybody can sign into a Snapchat.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, Demons, his counsel, the assistant state attorneys, and the ladies and gentlemen, jury. Ladies and gentlemen, I hope you have a nice evening, and I think we're ready to proceed. United States, you want to call your next witness, please?
Yes, Your Honor. The state calls Tara Helsel.
There's that squeak. They still haven't.
Good morning. How are you?
Good, how are you?
You raise your right hand this morning.
Do you solemnly swear or affirm the testimony you should give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Tara Helsel.
Please spell your first and last name for the court reporter.
Tarah, last name Helsel.
Thank you.
Please have a seat. Also, the microphone in front of you, moves up or down, doesn't go back.
Okay.
Great.
Yep.
Counsel, you're ready to proceed.
Thank you. Good morning.
Good morning.
Can you introduce yourself to the jury and tell them where you're currently employed?
Yes, my name is Tara Helsel, and I work at RJ Lee Group.
And in what capacity do you work with that group?
I am a forensic scientist and the manager of the forensics department
How long have you been employed by RG?
since November of 2016.
Can you give the jury a background into your education?
Yes, I have a Bachelor of Science degree in forensic science from Waynesburg University.
And how about some of your training and certifications?
Sure, so I had to complete RJ Lee Group's training program for gunshot residue analysis. And this was a several month-long process that involved reading and learning the standard operating procedures, reading relevant publications about gunshot residue. I had to complete the analysis of 250 case samples, of which my results were compared to that of a trained analyst. I had to receive training on the scanning electron microscope, which is the instrument that we use for our analysis. I also had to take a test about that instrument, a test about gunshot residue overall, and then following all of that, I also had to take a competency exam.
And can you tell us, you mentioned that you also supervise?
Yes, I'm the manager of the department as well.
How many individuals do you supervise?
Right now, just one.
And so you're responsible for their overseeing their work as well.
Yes, absolutely.
And how many times have you ever testified in court regarding the area of GSR?
84 previous times.
And in the state of Florida
Yes, I believe 13 of those were in Florida.
and other states as well?
Yes, I've testified in 20 different states, as well as Puerto Rico, Bermuda, and Turks and Caicos.
Has your entire professional career in the area of GSR been with RJ Lee?
Yes, it has been.
Can you explain to the jury what is gunshot residue, commonly referred to as GSR?
Yes, so gunshot residue in the broadest sense of the term is referring to all of the particles that result from the discharging of a firearm. However, when I am talking about gunshot residue, I am referring specifically to the particles that come from the primer, which is one of the parts of the cartridge.
Okay. And what is the primer? And you can give us kind of a summary because you did hear from an expert yesterday regarding it.
Sure. So when you're thinking about a cartridge, it has the projectile or the bullet in it. It has gunpowder. And then at the bottom of the cartridge is something called the primer cap. And inside of there is a mixture called the primer. And that contains a couple of different compounds that together contain the metals of lead, barium, and antimony.
So lead, barium, and antimony.
Yes.
Okay, we'll remember those three. So how is it that gunshot residue is produced and deposited in a manner in which you then analyze?
So whenever a firearm is discharged and the trigger is pulled, this causes something inside of the firearm called the firing pin to strike the primer cap. So it'll hit the bottom of that cartridge and this will start a reaction. So this will cause the primer to burn, and the burning of the primer causes the gunpowder to burn. So as the gunpowder burns, there is a buildup of high heat and, as a result, high pressure inside of the firearm. And that buildup of pressure is what ultimately will expel the bullet from the firearm. But because of that buildup of heat, those different elements I mentioned, such as the lead, barium, and antimony, are also going to heat up and become a gas. And this gas will exit the firearm through any available openings in the form of a vaporous cloud called a plume. So you have this gas exit the firearm, and it's now much cooler outside of the firearm than it was inside of the firearm. So those different metals will cool down and combine together and form particles. And those particles will land on the area surrounding the discharge. And those are the particles that I am looking for in my analysis.
And in general, how far is that gas traveling?
It depends on the environmental conditions. Things like weather and airflow can play a role. But in static conditions, typically about 4 to 6 feet.
Okay, and you mentioned the particles. What are the particles that are being produced by the discharge that you're looking for?
So there are 3 different types of primer-related particles. So the first are called particles characteristic of gunshot residue. And these would be particles that have lead, barium, and antimony all together in one particle. So these are considered characteristic because there are very few other sources of these particles aside from the discharge of a firearm. And it is the presence of those that we need to have to be able to call a sample positive for gunshot residue. There are also what are called 2-component particles, which would be any particle that contains 2 of those 3 metals. So it could be lead and barium, or lead and antimony, or barium and antimony. And these 2-component particles also can come from the discharge of a firearm, but there are other sources of them. So when they're found by themselves, they're not as conclusive to the presence of gunshot residue because they could have come from something else. But if they're found in combination with particles characteristic of gunshot residue, they're more likely to be from the discharge of a firearm and are kind of acting as part of that GSR population. And there is a third type of particle, which is just a 1-component particle, which would be lead by itself, barium by itself, or antimony by itself. And these also come from the discharge of a firearm, but there are even more other sources of those particles to where they're not very conclusive to the presence of gunshot residue. So we, our RGLE group, do not report on those. We are just reporting on the characteristic particles and the 2-component particles.
And that's because, for instance, lead can be found in paint.
Yes, absolutely.
So the presence of lead in and of itself isn't indicative of GSR.
Exactly.
And can you describe for us how you perform the analysis? And I know you brought up the microscope, which was briefly mentioned yesterday. Can you describe for us how that microscope works and your process?
Yes, so we use an instrument called the scanning electron microscope, which is also referred to as the SEM for short. So this is a very powerful microscope and it is computer controlled. So instead of looking at your samples through an eyepiece like you would in a traditional microscope, you're actually looking at them on a computer screen. And this instrument has the ability to magnify by thousands of times. And it also allows you to see the chemical composition of what you are looking at. So because gunshot residue is extremely small and not visible to the naked eye and is made of very specific elements, that's why we use the SEM. And the way our analysis actually works with it is 2 parts. So the first part is an automated analysis. So I will take the samples and put them into the microscope, and I will set up parameters on the computer telling it, here are the samples I have, here's where they are located on my sample folder. From there, the computer will scan the surface of those samples, looking for potential gunshot residue related particles. If it comes across something that it thinks could be gunshot residue, it will stop and take a picture of that particle and also save the coordinates for where it is located on that sample. So it will finish going through and scanning all of the samples, and after that, I will do the second part of our analysis, which is the manual analysis. So I will go back to those particles that the instrument flagged, and I will examine them. So I will look at their shape, and I'll see if that's consistent with gunshot residue, which would be something that is smooth or round in shape as the result of a high heat reaction. In addition to that, I will look at the chemical composition of those particles and make the determination for what type of particle it is that I am looking at.
And the automated process is performed by the SEM, right, the SEM for short.
Yes.
And what is it looking for? Those particles that we discussed earlier, or the compounds, the barium?
Yes, so basically, the way the SEM works is kind of based on brightness. So the more dense something is, the brighter it will appear. Because lead, barium, and antimony are heavy metals, gunshot residue related particles will appear very bright. So it's scanning the samples based on brightness. And if it finds something above a certain brightness, that's when it will stop and collect a spectrum to determine what elements are in there. If there's lead, barium, or antimony, or any combination of those, that's when it will save where it's located and take a picture of that particle.
And would a demonstrative aid assist you in your testimony to the jury as far as what the SEM shows?
Yes.
Again,
Enjoy,
ladies and gentlemen,
RA.
the witness is going to be using a visual or demonstrative aid to assist in explaining or illustrating her testimony. Just remember that the testimony of the witness is the evidence. However, this demonstrative aid is not to be considered by you as evidence in the case unless it's later received in evidence, and you should not use it as a substitute for evidence. Only items that are actually in evidence will go back with you to the jury during your deliberations. You may proceed, counsel.
Thank you. And without getting into the actual results, we're just going to orient the jury to the chart that I have here, beginning with the top left.
Yes, so the top left is an image kind of showing where the particle is located on the sample, and that is taken at 400 times magnification.
And the top right?
That is now a closer up image of that particle taken at 3200 times magnification, where you can see clearly that it is bright, it is round in shape, and you kind of are able to visualize really the morphology of that particle.
And bottom left?
So that is what is called the EDS spectrum. Basically, it's just showing you what elements are present in that particle. So PB is lead, BA is barium, and SB is antimony. So you see peaks for all of those present in that particle. Therefore, it is a particle that contains lead, barium, and antimony, which makes it characteristic of gunshot residue.
And are the peaks that we see consistent with the amount of that compound within the sample?
Yes, overall, the height of the peaks relate to how much of that element is in the particle.
And finally, the bottom right.
So that is the image that the instrument takes during the automated analysis.
And did you receive a sample in this particular case for analysis?
Yes, I did.
Your Honor, approaching defense counsel, which been previously marked the state's LLL for identification purposes.
Yeah, she does give a good explanation of things.
Your Honor, permission to approach the witness.
You may.
And if you need to handle anything biological, there are gloves right there, and the top has been open for ease of access. Tell me if you recognize it first, and if you need to open it, if you can just keep it outside the view of the jury.
I do recognize it.
And how is it that you recognize it?
This is one of the items that I received in this particular case.
And it was one sample, and what did that sample contain?
It contained a collection stub labeled as coming from the inside of a Jeep.
Okay, and is that in the same or substantially the same condition as the last time you saw it?
Yes.
Your Honor, at this time, the state would use into evidence, which is pre-marked the state's LLL as the next numbered exhibit.
No objection.
Thank you. It'll be admitted. What's the next number?
60.
60 in evidence. Thank you.
His family's still coming in. I'm seeing the text or the tweets, and his family's still coming in. His little sister got there. His mom's gotten there. It's
Looking for 57.
Ari's going
I'm showing
canoeing.
you what's been entered into evidence. It states 57. Do you recognize that?
I do, yes.
And what is that?
This is a gunshot residue kit that we received in this case.
And did you analyze states 57?
Yes, I did.
And did you ultimately analyze state 60?
Yes, I did.
So, grab your scissors.
I haven't heard anything else about the issue outside yesterday.
Go ahead.
I didn't find anything else about it.
I'm gonna ask permission from the judge for you to step down.
You may.
If you wanna open it, grab some gloves and we'll.
Okay.
Oh, Sherry Smith, the closing arguments are already happening for the sleeping father case.
Just if you can publish states 57. And the contents. So you received one sample, but there are 2 tubes.
Yes.
What are they representative of?
These were samples that we had received that are labeled as coming from the right hand and the left hand.
And who's the individual?
Cortland Henry.
So this is the driver.
And you can put those back in. And if you can publish states 60.
At least they don't have the scissors right in the. They're not as loud
We
as
have
they
one
were.
tube, and what is that representative of?
It is labeled as coming from inside of a Jeep.
If you believe it, it will adjust. Thank you. You can put it back in and keep your seat.
I don't think there's court Monday. We have a 3-day weekend.
Okay, we're gonna start with case 57. Did you ultimately have a chance to analyze and go through this SEM process, which is the automated process, and your individual process, in order to come up with an opinion as to the presence of GSR?
Yes.
And what was that opinion? And if you can specify both the left and then the right.
So the right hand of Cortland Henry contained 0 particles characteristic of gunshot residue and 2 two-component particles. And the left hand contained 1 particle characteristic of gunshot residue and 1 two-component particle.
And can you explain to us what that means?
Basically, overall, there was gunshot residue present on the hands.
Okay, and what affects the presence or absence of GSR on a person's hand or any object?
Sure. So if there is gunshot residue on someone's hands, that means that the individual got it on themselves by either discharging a firearm, being in the proximity of a firearm when it was discharged, or by coming into contact with a surface or object with gunshot residue on it.
And if we may go back to the demonstrative aid, what was this demonstrative aid? Was this representative of your results with Portland Henry?
Yes, that was the particle characteristic of gunshot residue that was on the left hand.
And the components which you explained before, there are three kinds or three compounds that you were looking for, and which compounds were present in Portland Henry's left hand.
Lead, barium, and antimony were present in that particle.
So all three components.
Yes.
Okay, and let's move on to stage 60, which was the sample for the G. What were your results? And again, did you also go through the SEM automated process and then your individual characteristic process?
I did, yes. So there were 0 particles characteristic of gunshot residue, but at least 9 2-component particles.
Okay, and what does that mean?
So, like I mentioned, 2-component particles can come from gunshot residue, but they also have other sources. So, because of that, these results are basically inconclusive. They could be gunshot residue, but they also could be from something else, and I can't say which it is.
Okay. In your analysis and reviewing the sample, did you find anything inconsistent with gunshot residue, if I'm phrasing that correctly?
Correct, and I did not. So overall, with 2-component particles, or any of the particles we look at, if the particles are from another source, there are other elements or amounts of elements that would be unusual to find in gunshot residue. So, for example, one common source of 2-component particles is brake pads. Brake pads typically contain high amounts of the element iron. So if I'm doing my analysis and I come across particles with high amounts of iron, I eliminate them and I do not report them because there's something about them that would suggest they're from something else. So while I still cannot call these particles gunshot residue, there was nothing about those particles that were unusual.
And I want to ask you about presumptive tests. Are you familiar with them in general?
I am, yes.
Are you familiar with the friend or foe presumptive GSR kit?
I am.
What is that kit testing?
That kit is like you said, a presumptive test that is looking for the presence of nitrates, so nitrogen containing compounds.
Okay. So for instance, these GSR kits are made to essentially alert to the presence of a certain compound.
Yes.
And the friend or foe kit specifically alerts to the compound of nitrogen particles.
Yes.
So the presence or absence of nitrogen particles.
Correct.
And are presumptive tests relied on exclusively?
No, they are just a screening tool. Like I mentioned, they're looking for nitrates, and there are many things that can contain nitrates. So they are not conclusive to the presence of gunshot residue or gunpowder. They are really just to be used as a screening tool.
Your Honor, move to confirm?
Yes.
Nothing further.
Councilor Zane Cross,
Yes,
you're ready to proceed.
thank you.
That's squeaking.
Good morning.
Good morning.
I don't think we've had an opportunity to meet.
No.
You got the sample from Miramar Police Department,
Yes.
specifically Detective Moretti directed it to you.
Yes.
And when we talk about GSR, or gunshot residue, you're aware that GSR can be found on clothes, right?
Yes, that's possible.
Did Detective Moretti send you any clothes of Cortland Henry?
He did not.
He didn't send you any of the clothes?
No.
Did you know that the clothes of Cortland Henry were collected by the Miramar Police Department?
Objection, calls for speculation outside the scope of court.
Well, I don't know that it calls for speculation. She knows she can answer the question. Overruled.
Were you aware that the Miramar Police Department collected Cortland Henry's clothes?
No, I was not aware of that.
But if in your examination, had you received clothes, you could test those clothes for GSR, correct?
Yes, we can
And you-
certainly test clothing.
And you've done that many times, correct?
Yes, absolutely.
Also, if someone is in a hospital, in a bed in a hospital, do you know if that person has washed their hands?
I don't.
And by washing your hands, you can get rid of GSR, correct?
Yes, hand washing can remove most, if not all, of the particles on someone's hands.
Do you know if Cortland Henry washed his hands or changed his clothes?
I don't know that.
Can I have one moment?
Yes, ma'am.
They're wanting to create the
Thank
doubt
you very
that
much.
it could have been the driver.
Redirect.
Yes, Your Honor. Is hand washing the only thing, contrary to popular belief, that removes gunshot residue?
No, gunshot residue is easily removed in general. So with respect to the hands, any type of activity, touching or use of the hands can remove particles pretty easily. With clothing, any activity. So if the garment is touching things, if it's laundered,
If it's removed?
yes, any activity can cause particles to be disrupted or removed.
And you're an independent lab, correct?
Yes, we are.
You're not associated with Miramar Police Department.
Correct, we are not.
You're not associated with the Broward Sheriff's Office.
We are not.
So you can only test what you're submitted, correct?
Correct.
Nothing further.
One question.
Yes.
If I may. You were hired by the Miramar Police Department to perform this test, correct?
Yes, they're the ones that submitted the samples.
Thank you.
Anything else?
No, Your Honor, nothing further.
Is this witness excused?
Yes, Your Honor.
Thank you very much, ma'am. Can you step down your excuse?
So this is kind of what she just said is kind of why Mark Shiner was telling us in the interview that it's not as there's a sidebar. What is that, number 2 or 3? That's why Mark was saying that there are issues with the GSR testing, why they don't.
Please do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in presence, and search and no research. Thank you, just leave your notepad on the chair.
Taking a break already. Oh, let me unpin that witness. Let's see. Yeah, like they just started 45 minutes ago. We're already taking a break. We ain't gonna be done with this trial until 2029. We live here now. Lucy does not bring flip-flops to my mom's.
Let the record reflect,
I only have my 2.
the jury stepped down, counsel remained, along with the defendant and the assistant state attorneys. So I have, and this has been marked as states JJJ, triple J, and it's a Snapchat account. And so what does this purport to be?
That is the business record production from Snap Incorporated, which is the business that runs the social media app of Snapchat. The records are the records of Mr. Defendant Jamell Timmons. They are conversations and statements that he makes, some of which reference this homicide and Portland Henry. There's in specific comments from Mr. Timmons to an individual that's identified by a Snapchat name, and it's on there, DHAT is what it starts with, in which he says that Cortland Henry did something very important for him. I'm paraphrasing from the language on that. In terms of establishing that those records belong to the defendant, the state has to prove that beyond a reasonable doubt to the jurors. So that is why it's necessary to show that all of the photos and videos in that particular item are of Jamell Timmons. In addition, the person that he is speaking to, the one that starts with DHAT, that individual, there are images of her that are transferred back and forth. So that is identified as Mariah Hamilton. That is the defendant's girlfriend at the time. She's also in some of the videos. And then there are videos that the defendant sends to her that in which he indicates you shouldn't be speaking on me, basically discouraging her from speaking with law enforcement.
So, regarding these videos, how long are they? How many? I mean, you sent me
Yes, that's
3
the,
pages listed. I don't know how long these take to take a look at.
they're less than 30 seconds each approximately.
So let's put them in.
The drive that is right there.
Or is it angle that?
Yeah, that's fine now. Just has to go back. But I want you to sit over there. Is RFP sit over there? Or they're good?
I think that might be good.
You can reposition yourself.
Yeah.
Maybe. Thank you. And feel free to do that throughout.
Thank you.
If there's
Okay, so
something
these
showing
are-
on the screen and you think you want a better view of it, you're always welcome.
And this is the business records certification as included on the file from Snapchat.
Yeah, I saw those. I'm not talking about that, I'm talking about the actual videos.
So do you want to see the images larger as well, Your Honor?
Yeah, I'd like to know what you're gonna show to the jury.
Of
They're
course.
objecting to it, saying it's not relevant. You know, I don't believe there's an objection that's not authentic, that it's, not his account from Snapchat. I understand that.
He just blew out my ears.
My understanding is they're saying it's not relevant.
This is the one that I indicated would potentially have the items the defense didn't want in, such as the names of the songs of the defendant.
We don't have to concern ourselves about that. The state agreed to get that, so.
Image of the defendant, an image of the defendant and Mariah Hamilton. Image of the defendant,
Now, you're saying that this is the defendant and Mariah Hamilton, and I haven't heard anybody identify her yet. Is that, I mean?
correct, that's why the next witness would do that.
Oh, okay, so the witness is gonna do that.
Yes, Your Honor. There she is again, that is Ms. Hamilton. This is the Snapchat logo of the defendant. Moving on to the videos. This video here is before the homicide. It includes the defendant and one of the victims, Christopher Thomas. There is volume to it. I don't know if the TV is turned down.
Gary, can you check on that?
That's good.
That's 63 or 62. There is a volume.
There's conversation that they're wanting in that was in Snapchat. It's in the probable cause affidavit. A couple things.
tried VLC.
That was VLC, so.
A lot of this is just establishing that it is his Snapchat, so that when they try to get the conversations that were had on Snapchat, when they try to get those entered into evidence, they're trying to show that it was
Can I
definitely
almost
coming
switch
from
over
him.
to a different computer?
So like when defense said anybody could log into his Snapchat, they're trying to show the extra stuff to show that it was him accessing his Snapchat. And there's a couple sentences that they want to get entered in. There was a conversation where he said something about, I can't remember the exact words, but something about how Bortland did something for him that, something major for him. And they're saying that that refers to Bortland covering for him with all this. Yeah, they need a Doug with the Elmo, for real. I'm like scared to see what we're gonna see here.
Sorry.
Jesus. Gosh, she must have had that speaker right by the microphone.
This bitch look like you got 5 kids at the student pickup right now, waiting.
Your Honor, for the interest of time, should the state be proffering the relevance of each video as we go?
No, thank you. I'd just like to see it and see what
Right.
my understanding. Well, go ahead.
Okay.
Right. All right, thanks for shaking that. Maybe the most important shaking. The most important shaking. Like, get right there, like, you know you come back. You be so big on me. I've seen 750,000 each. I ordered it. It'll be a meal. But I make sure. It'll be a meal. I make sure. People say we get out. People say we jumped our ass, man. We jumped our ass, man. Hey, bro, don't be speaking on you. Don't do that. He didn't do that. I've been out here about your ass saying you did.
Those all the videos, Council?
Yes, Your Honor.
All right, so, Council, I want you to tell me your complete objection so I fully understand what you're objecting to on the videos as well as the remaining portion of this Snapchat under, I think it's triple J.
Your Honor, our first objection would be relevance. I think Florida statute 9401 defines relevance as evidence tending to prove or disprove a material fact. There was not a single video that you witnessed there that implicates in any way any fact and issue in this case. I want the court to be aware of what a Snapchat account is versus a video off of a phone. They're two different things. You can access that Snapchat account from your computer that's right before you. So a Snapchat account or any social media account is not particular to a device. This is contents from an account that exists in the cloud or on the platform of Snapchat and is not peculiar to a particular device. So it doesn't identify a device. It identifies a social media account. The notion that anything a defendant says can and will be used against him is an issue of hearsay. It's not a relevancy issue. None of those videos I haven't heard, and I think that probably we're putting cart before the horse by making me object to the relevance before she advances her theory of relevance. But the fact is, unless I'm missing something, there is nothing there that concerns the events of October the 26th, 2018 in any way. As far as the messages are concerned, it's similar.
Now we're talking about what's in writing, correct?
What's in writing is essentially a dump from that account, a selective dump, I think from August the 3rd through some date in November. If the state is indicating that there are messages there that relate to the offense, then the state should isolate those messages and make its argument as to what the relevance of those statements is or are. But to suggest that you can just dump all statements that somebody makes since birth, until the time of their trial. And because it's non-hearsay because it's a statement of the defendant. And by the way, these are exchanges. So a relevancy of objection, or sorry, a hearsay objection relates to the statements of the defendant, not the ones that are made back to him in any kind of conversational exchange. Those statements themselves are hearsay because they aren't statements of the defendant. And I'm making this argument assuming, because I'm dealing with relevancy, assuming that those statements are indeed statements of the defendant, which I'm not conceding. They have to have some relevance to this trial and facts in issue at this trial. There are some statements that I observed that seem to be some maybe terse or conversations between him and any person that might cast him in a poor light because of the manner in which he communicates. How is that relevant to this case? So relevance is number one. A statement has to be relevant. So each statement the state would have to establish the relevance of each statement in isolation prior to it being admitted into evidence. Saying these are all from his phone and therefore they're all his statements and this is a business record exception and therefore they get in doesn't cut it. As far as authenticity is concerned, and that's our relevance objection. Relevance must be established. I'll cite the court authenticity issues or authentication issues concern Rule Florida Statute 90.901. And I'll cite the court to some case law that doesn't necessarily deal with social media, it deals with text messages and emails. Simonet. I can't remember if it's Simonet v. State or State versus Simonet, but it's 100 Southern 3rd 180, which stands for concerns text on a cell phone. And it indicates, these are some notes that I took down because I didn't realize she was going to be trying to bring this in today. We had asked for some indication as to the witnesses. And I think this is the only day we didn't get any indication. And so there's an element of ambush. But nonetheless, in the Simonet case, it stands for some legal principles that were articulated in that holding that I took note of. One, in that case, there was concern regarding the admission of screenshots of text messages, communications. And the court said it was okay because there was a witness that testified that she was sitting next to the defendant in a car when the texts were made. And the detective recovered a cell phone from the defendant, and the witness identified the text messages between her and the defendant. In other words, there was a party to the communication who was able to authenticate the communication and who the participants are. Another case is Roy, which is 279 Southern 3rd 238.
279 what?
Southern 3rd 238, which concerns emails and texts. And these were emails that were admitted through the investigator that was posing as a 14-year-old in what appears to be a case that concerns some sort of a pedophile sting. And the investigator involved in the exchange, the investigator was involved in the exchange in the emails of the text. One of the quotes that I took from that case says, most common way to identify social media, which would be this, and things akin to social media, is to let the author testify that they're the ones who generated or created it. So there's somebody that is involved in the exchange of the communication that can attest to the fact that they created it or were involved in it and identify the parties that were involved in the exchange. When a participant is used to authenticate electronic exchange, the focus is on the witness's ability to identify the person against whom the communication is offered. In criminal cases, the person communicating with the target of the investigation must be able to identify the target through some personal knowledge or experience. So this establishes that there has to be somebody who participated in the communication, who authenticates the participants in the exchange, and must be able to identify the participants in the exchange. In the Roy case, the sergeant, who was posing as a 14-year-old, acknowledged that he had no idea who was on the other side of the emails and texts. Here we have nobody at all, let alone somebody whose knowledge is insufficient.
This is just a PC affirm case. These opinions are, right? Am I reading this right? This is a PC affirm. That's in the concurring opinions or?
Roy versus State. I can print it out if you
I'm reading it right now.
I'm not sure that what the court is.
It's a PCA affirm.
Meaning the language that I'm reading doesn't exist?
Not, it exists, I'm sure it's there. I didn't read the whole concurrence. It's
Okay,
there, but it's a PCA affirm.
Well, maybe I cited it incorrectly. I
No,
have.
you cited it right. 279, Southern 3rd, 238. All right, go ahead.
Okay, this is language I took from the cases themselves.
I don't doubt it.
Okay.
Seems like it's all here.
Okay. I'm not sure the significance of a PCA affirm meaning.
That's not the opinion of the court. It's the opinion of one judge. That's what his concurrence was. His or her opinion, and there's another judge has a different concurring opinion. There's no specific majority opinion. I don't see one. The other concurring opinion says he reversed, but it's a PCA affirm.
I'm not quite sure of the significance of that, but I'm sure the court has a message that's communicated. No evidence that the texts were recovered from a phone, belonging to, in the possession of, the appellant pursuant to a search warrant, is another quote. Further, in that case, the sergeant could not identify appellant as a person on the side of the emails or on the other side of the emails or texts. Lamb versus State, 246 Southern 2nd 400, a 4th DCA case in 2018. A quote that I took from that says, a case involving authentication of a Facebook video, or videos here, is also instructive. In that case, the 4th District recognized a distinction between authentication of a video recording and an audio recording. An audio recording would be more akin to a communication that you can't tell the identity of the communicator's visual. The 4th District acknowledged its prior holding that authentication of an audio recording, quote, should be made by the technician who operated the recording device or a person with knowledge of the conversation that was recorded. Quoting Santana versus State, 191 Southern 3rd 946, which is another 4th District case. So as far as authentication is concerned, Your Honor, and the PCA affirmed component, notwithstanding, the articulation that is being made repeatedly by district courts of Florida, of this state, and by the 4th District, are that when you are introducing text messages, communications that are in print, audio, somebody has to identify the participants. You can't just put them in and say, this is the guy who said it. You have to lay a predicate of authentication, which the state is not attempting to do. So as far as relevance is concerned, they have to establish relevance of each statement. They can't just say, here are all the communications he ever made, and notwithstanding who he's making them with, whose statements are themselves hearsay, because his statements are statements of the defendant and therefore not hearsay, non-hearsay by definition, they come in, they have to establish the relevance. So we object. One second. So the communications are not particular to a phone, so it doesn't meet that hurdle. They are particular to a social media platform. A social media platform that they have to establish belongs to the defendant, and I don't think they have said how they purport to do that. Even if they do that, the statements of anybody else in those exchanges is hearsay. Statements of the defendant are irrelevant, and the photographs and videos are also irrelevant and prejudicial pursuant to 90.403.
Thank you, and I misspoke. It was one opinion, it's a PC affirmed on Benjamin D. State, or Benjamin D. Roy v. State, that you cited, 279 Southern 3rd, 238. It's a PC affirmed, there is a concurrence, and he would concur in part and would reverse in part. I misspoke. All right, so yes, counsel, you want to be heard?
Yes, Your Honor, with regards to, and defense counsel already has the Lamb case, so I'll just provide a printed copy to Your Honor. Specifically, authentication for the purpose of admission is a relatively low threshold that only requires a prima facie showing that the proper evidence is authentic. I'm reading on the 9th page of notes 5 and 6. Your Honor. Lamb case goes on to state that authentication for the purpose of admission is the ultimate determination of authenticity of the evidence is a question for the fact finder. Evidence may be authenticated by appearance, content, substance, internal patterns, or other distinctive characteristics taken in conjunction with the circumstances. In addition, the evidence may be authenticated either by using extrinsic evidence or by showing that it meets the requirements for self-authentication. With regards to the evidence that's before Your Honor, the defense is not agreeing that it's his account. So then the burden is on the state to prove that it's his account. As such, the evidence itself shows that it's authentic as it is the defendant in every single one of those videos. In terms of the contents of the defendant's statements, they are relevant. They go to the issue at fact of whether or not he committed these two homicides. The contents of the questions are important for giving context. An answer without any context doesn't give the fact finder, the jury, any way to meaningfully evaluate the statements. So based on the standard, which is low for authentication, the state has done that by the business record certification and the fact that the email address and everything else will be linked up in other witnesses as well, showing that that was the defendant's particular iCloud account that is the username. It's also important to note, Your Honor, that while the individual, that doesn't tie it to a specific device, it ties it to a specific individual because it's a unique logon and username and password, just like an email account, that it was used by this defendant.
Thank you. Anything else, counsel?
Yes, Your Honor. There are statements there that, in the conversations that started on October 3rd. October 3rd, this incident occurred on the 26th. The state is making a blanket assertion that these statements go to demonstrate his complicity in these homicides. Each statement has to be identified and the argument has to be made as to each such statement by itself so the court can have a way of evaluating the purported relevance. They can't just say they're relevant to the homicide. That is insufficient. And if they do not identify each particular statement and the relevance of each particular statement, then dumping them all in on some blanket assertion that they're relevant would be error, and it would invite error, and it would prejudice Mr. Demons irreparably. So context for what? He's having an argument, a discussion with somebody on October 3rd, if they're saying that that constitutes some plan that establishes premeditation, then let them advance that argument. They have not referenced a single one of those conversations with specificity and advanced some argument that ties it to a fact and issue in this case. So I would say that on the relevance alone, the state fails to make a showing that would allow the court to even properly analyze the question and issue.
Thank you. I'm going to defer ruling out. Take a look at your cases that you just sent. We're going to take a short recess. Mr. Demings, any restroom break?
Yes.
Yes? Can you arrange for restroom break? Yeah. We'll be in recess. Thank you.
See if we can hear our hot mic. I think they learned their lesson on it. Okay, so they were going over some case law stuff. I saw some of the people who think that that's really cool to see, and then I see some people who are like, this is the boring stuff. So it kind of depends on how you look at it. But it's interesting the way that social media and in all the different forms and everything attached to your phone, it's crazy to see the role that it plays in trials now, especially social media with the younger ones. Let's see. Yes, this is a death penalty case. And that's part of why the jury selection took so long. But the new law in Florida is that only 8 out of 12 have to vote for death penalty for it to be considered the jury recommendation for the judge. Let's see. Yeah, so the Snapchat stuff that they had in the PCA, let me pull it up real quick. I typed it in a second ago, so I already had it pulled up. Let's see, they did a search warrant for his Snapchats, direct messaging of the Snap account of Melly revealed he was communicating with his girlfriend on 11/9. So this is 14 days after the homicide. And he said that he was talking about Portland, and he said that he saved my life. So he's coming everywhere with me, because if they come grab him up, it's my fault. You forgot. And then they're saying that he's saying that, Portland, who was the driver, of course, is coming everywhere with him, because if the state's theory is that this is saying if the police come get him, then, he says, it's my fault. You forgot. So he's saying, remember, if they come get him, it's my fault that this happened. So he wanted to keep Portland around him. And then it said, after that, it said, I keep Portland with me because at the end of the day, he did one of the realest things in my life. I paraphrased. I'm keeping out some of the cursey words because we can only do so much without YouTube fussing at us. So the PCA, this is what they're saying. This is what it reads. These are interesting statements as they are referencing Melly's loyalty and association with Portland. He said that They also suggest that Bortland was loyal to him because he is the one who drove the bodies to the hospital and dealt with law enforcement. And they said these statements also support the belief by law enforcement that Melly is the shooter, and the evidence leads back to him. And any further cooperation by Bortland would be damaging to Melly. So that's part of the Snapchat conversation they're wanting to get in. Also, the GSR, when she was going over it, that was kind of the same stuff that Mark was saying, that it's not conclusive. It's kind of like just more like a screening test, kind of like lie detectors, how they're not admissible in court as, well, they're not admissible in court at all. GSR is admissible in court, but it's not, it's left up for the jury to decide the weight or value of it. But that was like when he was questioning her about it, and she was saying, yes, there are other things that can cause it to react, and talking about the different components, how some of them are two particle, or two, oh gosh, I can't speak today, or what was it, two component particles. Couldn't get it out. Two component particles, and those can have the reaction because of other stuff too. So it's just a presumptive test, looking for nitrates, but it's not 100% definitive, basically. And the way the defense was questioning her about that, it sounded like, they were saying, so he could have washed his hands and he could have, gotten rid of the GSR. It sounds like they're possibly pushing the theory of this all being Bortland who did it, and creating that like as an alternate theory for the jury to create doubt. Maybe that's their theory. I'm really interested actually to see what the defense says as their theory, if they're going to present something else, or if they're just going to, debunk what they've said, because they don't have to give somebody else. They don't have to give an alternate theory, just like the prosecution doesn't have to give a motive. They don't have to, but it definitely helps the jury to think about, okay, well, if you didn't do it, then who did, or how did this happen? So I'll be interested to see how they present their defense. The attorney's good, though. Let's see. Oh, I've still got this pinned. Oh, no, I unpinned it. All right, let's see. Yeah, Bortland is, I call them all by their stage names, because that's how, when I was looking everything up, that's how I memorized them. But then they refer to them by their names in in court. So Christopher is Juvie, and Bortland is, it's really Cortland Henry, but they won't, if you miss statements, they won't use the C's, they change them to B's. Oh, my voice is getting scratchy. Let's see. The other one, yeah. Anthony Williams. Anthony Williams is sack chaser. or they call him Sack. Some of them call him Sack. And then Christopher Thomas is Juvie. He was the one who was in the back seat, and he's the one whose dad did the interview with Anjanette. They have been friends since they were kids. Their parents knew each other. Chris's parents, his dad said in that interview that that they had known each other. I think Melly was born in 99, and he said that they had known each other since 99. And then one of them, I think they said, I saw on one of the videos where they said that he met Juvie, I think, when he was in kindergarten, and then he met Sack when he was in 8th grade, I think is what it said. Let's see. Yeah, I graduated in 01, so yeah, Melly was my son's age. I've said that before. Melly was my son is 19. He'll be 20 in a couple months, and Melly was my son's age when this happened. It's crazy. I'm getting old. It's crazy to look at, somebody my son's age and think something like this could happen. It's crazy. Let's see. The phone evidence is going to take quite a while. It's tedious. They have step data too. She brought up, I put it in the recap video from the other day, but they have step video or step evidence too that during the time, that was part of what they're using as their, how they found their, or formed their theory, I guess I should say. So when he left, when he got out of the car, he FaceTimed his girlfriend. So his girlfriend and her mom both saw him on FaceTime and he said he had just been involved in a drive-by. And then he dropped a pin location to Fredo Bang and had told him to come pick him up. And then 11 minutes later, dropped another pin location to Fredo Bang to tell him where he's at. And in between those two pin drops at 11 minutes, every time he had moved before, it was like 70 steps, here and there, whatever. And in that 11 minutes, he counted like, I can't remember, like 1,300 or 1,600 or something like that, like something, a lot. So that was part of how they developed their theory, saying that, he got out of the car and he sent the pin for him to come get him. He continued walking to get away or whatever and get further away, and then sent the second pin, but that there were so many steps in between. So they basically took all of the information they could and kind of lined it up together, and that's how they came up with their theory. They kind of followed the evidence. Let's see. It's crazy how much the phones give away. Like, when was the last time y'all watched a trial where phone evidence wasn't part of it? Except for the cold cases. They didn't have all the phone data back then. Now those are all DNA. Everything else has phone data. Let's see. VK says his manager picked him up. He may have. I don't know who came to pick him up. I know that the two dots that I might have it on my notes at my computer, but the 2 times where he dropped his pen was to they said was to Fredo Bang, but dropping the pen is the big part because it shows exactly where he was and then exactly where he was 11 minutes later. And he's got the step data to show, how he was walking during that time. Let's see. It was 15 minutes before they got to the hospital that he got out of the car. They sure do take a lot of breaks. Let's see. The defense attorneys definitely are creating doubt about him, but which is also, part of why they're not being tried together. Let's see. Oh, everything just moved. I've gotten all mine. Jane Dixon asked, why do people get tattoos? Honest question. I've gotten all of mine for different things. Well, the first few I just got because I was like, that looks cool, when I was real young. And then since then, all of mine have some kind of special meaning. I love my tattoos. But then there's a couple I got just because I thought, I like it. Looks cool. Let's see. The blanket. Okay, so they've said that it's extremely cold in the courtroom there, which is ironic because it's extremely hot here in Florida. Let's see. If the tattoos have special meaning, etc. All of mine do. That's a big dude, isn't it? Y'all see him when he walks through that door? He looks like a big guy. Let's see. That building is an architectural and functional flop. That swinging door is what drives me nuts. It's so loud. Let's see. Madam CJ No Walker says, I have a theory that it was the red car that shot the car up. It was an actual drive-by, and that Portland ended up shooting back to protect Melly. So the red car wasn't at the spot where the on the side of 27 where they found the matching glass and the shell casings. The red car never went there. There's the cell phone footage shows that they went home, and then they've got the video from where they entered the gates. So that one couldn't have, and the back passenger door where Melly was sitting was open when the outside shots were fired. So that's so I don't think that the red car could have done it based on the data and stuff where they went home. He's got on one side he's got his mom's name, and on the other side he's got Sack Chaser's mom's name, the one who was in the front seat. I guess he said they were all really close. Yeah, somebody got out and shot through the back of the car and the side of the car. No, it does not appear that way. No. Did I see the tweet about the victim's dad going off? I don't think so. I haven't been on Twitter much today, other than looking at the updates. Is this after the? This is not the interview. You're talking about something that happened after? I'll look. Let's see.
This is the attorneys, jurors in the jury room. Counsel, I've had an opportunity to take a look at your cases and read over a little bit more about Snapchat. And my thought is this: I understand the defense objection, I'd be admitting it, allowing the evidence to come in. However, there's a couple caveats. Number one is one of the videos I saw has a gun in it. This is all.
Just access to the murder of firearm 6 days before the homicide.
Right. I don't see how that is relevant to anything, and I think it's more prejudicial and probative, and it shouldn't be. All right. So I'm not allowing that weapon. It's not like you had something 15 minutes or a half hour before the incident in question. I'm not letting something in with a gun, days before. That's number one. Number two, I know there's been no argument the 403 analysis, but I don't see how any of the pictures and the videos with all the flash and the cash and all that really has anything to do with anything. I want all those out. I'm not admitting those. All right?
So the videos of him in the bathroom with the stack of cash.
Anything where he's flashing all the cash, I don't see how any of those things are relevant. They're more prejudicial and probative. The gun is more prejudicial and probative. I'm not letting them.
Okay, so what I'll do, with your next permission, is I will pull them up here and we can verify them. Then I'd be changing the business records on that. But that's important with your honor roll.
So he's making a ruling on the Snapchat stuff. He's not allowing everything to come in.
So that would be these 3 videos in a bathroom. Just with regards to this particular video, the second video doesn't have the defendant's picture in it, so just so it's clear. So we can- And so what I would suggest is that I can modify that video to take out the part where the gun is there, and then, so it would just go from there and then excise the portion where the gun is shown, because that is showing who is speaking and showing who is then showing the driver's license.
It's fine, the gun should be out. It's not,
Your Honor,
it staged before.
could she at least articulate the relevance of anything? I mean, I understand.
I heard your argument, I understand it,
Okay,
and I've overruled it.
it is overruled.
Overruled. The only thing I'm doing is on 403 analysis saying that you can't, I don't see the relevance, I don't see the probative value of the gun and the cash being outweighed by, overruled.
Defense counsel is also asking to take out the photo of the song and their titles from whichever else.
Right, I agree, take it out. Murder on my mind.
And so I just need about 5 minutes to fix that video.
All right, we'll be in recess, you work on it.
Thank you.
Yes, sir, you want to say something?
Yes, Your Honor. So has the court articulated its ruling concerning the visual images, the videos, the pictures? Or has the court also decided that all the communications come in without the state asserting a relevancy objection as to each statement, or a relevancy as to each statement?
Counsel, the videos, my understanding, the videos as well as the written conversations, or you articulated and objected saying they're not relevant and they can't be authenticated, things like that, and the objection is they can't be authenticated. We don't, because how Snapchat works, anybody could have done it. And counsel's suggesting to me that she needs to put it in to show that it's his, because he's the one that's picture on those accounts. It's authenticating. I know I'm the determination of what's authentic, whether it's authentic or not. I'm making that decision. But it appears to me it's going to be argued that it's not his account, or he's not the one that's putting this information on there. That's the tenor of what you're suggesting. So it just seems to me that goes to show who's on the account and whose account it is.
No, I understand that, Your Honor, and please do not understand me to be arguing a decision that the court has made. I'm trying to understand that saying that we're going to put all this in to prove, we're going to put in all these conversations to prove that it's his Snapchat account. Why are they trying to prove that it's his Snapchat account if not to get the very statements in? So if the statements themselves are relevant, saying, well, we're going to put in these statements to prove it's his Snapchat account, should they at least articulate why are you trying to prove that it's his Snapchat account?
There's a statement in there which there's the state believes is an admission.
Okay, well, if that is the case, then that statement should come in. And if those statements are isolated, then the defense would be in a position to determine whether or not they're going to take the position that it is not his Snapchat account and do a 403 analysis of our own. So if they're saying there are 3 statements in there that constitute admissions, fine. If they might want to put those in, and we might say, okay, we're not going to contest that it's his account, so you don't have to put in all the other stuff that is prejudicial. But they have to at least articulate it and isolate it so that they can make an informed decision.
Thank you, counsel. You didn't bring up the fact that there's a, it's overly prejudicial. You had a straight relevance objection and authentication objection. I've overruled those objections. When I looked at the video, I said, nobody else, I said, I think that's too prejudicial, not probative of anything, the picture of him with a gun, and I want it out of there. I said the same thing regarding the cash. You did tell me, and I didn't articulate it, that you were concerned about the video with murder on my mind, and I agree with that. That should be out as well. All right? Okay. So that's the ruling. It's the relevance objection is overruled. The authentication objection, I admit it, but I don't want the items that I previously discussed being shown to the jury.
Thank you.
Yeah, I mean, I'm going to show defense counsel the clip as it's been.
Go ahead. We're in recess from that. Show whatever you want to show.
Done. All the other ones are already taken out. This is the other one to take out the gun.
Yeah, they're, the stuff with the song and the gun and the cash, none of that's coming in.
On,
Yes, they are on each specific one.
could I see that diagram again?
Yes, it's there.
Rule 403 is where they don't let evidence come in because
You're in recess.
because the probative value, they said, outweighs.
Snapchat.
Sorry, I don't want to make sure I don't miss anything.
Identify what you think is a confession in there. Identify it, but I don't understand why you would not identify it, because then you might not make an objection.
He wants her to identify what she says is the confession.
Then it would be admissible based on her. Take out anything with cash into it. Everything's good. I'm not concerned about that. The judge said take him out, take him out. If you take him out, don't take him out, then. I don't need to.
Oops. I think they're trying to get that part, and then
Anything else that's an admission to sex?
I know there's the one thing where he says, "I did that," when they ask him if he's okay.
How about you take the position that if you think there are confessions in there or statements that implicate him, identify them. This is the only one.
Dispatch. On November 9th. On November 9th.
Telling me what I'm saying. I'm saying identify what you want in. Because what? You think it's all admissible to prove that it's his account. If we're not contesting that it's his account, then you're putting in some form of information. Identify what you want in so that we can make an informed decision. If you violate the judge's order, then it's your problem. I don't need to review it.
Seems to be some tension. He's asking her to, I don't know if some people can't hear, I know on whatever, depending on what you're listening on. He's telling,
Yes.
Okay. I'm not trying to. I know you're having problems.
Council's gonna take you a few minutes.
The video's
Yes,
done.
in a few minutes. Okay. Thank you for Allison just taking a piece. And we just wanted to be clear that if we are,
So you want to be on the record again?
yes, just so I can complete the record on this one point.
Let the record reflect the presence of the defendant, his counsel, the assistant state attorney, jurors, and juror. Yes, sir.
The state is asserting that among the conversations in state's exhibit, what was it, mark for identification?
Jay?
Triple J, that there are certain conversations or certain exchanges which she believes relate to facts and issue, and that the rest of them she is using to authenticate or to establish that it is the account of Mr. Demmons. I'm just putting on the record that the defense would be willing, if she does isolate those conversations, to consider not objecting or not making the claim that it's not his account, so that she can get in whatever she deems is relevant, and we can avoid the prejudice of the remaining contents that she intends to put in that is not relevant, and she only intends to put in to establish that it's his account. I just wanted it to be clear that that is an offer that we have tendered to the state, and we're articulating for the court. Thank you.
Thank you. What's the state?
Your Honor, the state is going forward that the state has to convince the jury beyond a reasonable doubt as to the authenticity and who those messages went to. And that was the way defense counsel indicated from the beginning that that is how the state needed to proceed. So at this point, the state would enter the evidence as it is currently put.
Thank you. Can I see you, please? Because there's whole conversations with Ms. Mariah Hamilton that really, that goes to authenticate the whose account it is, but I don't know that it does anything other than that. And can I see the exchange again, please? JJJ.
Oh, I left it right there, I'm sorry.
And Mr. Edelstein asked me to print another copy for him, so I'm trying to work on that.
I'm sorry.
I apologize.
No, it's my fault, I accept the responsibility. So the court, I get 2 or 3 points off my guidelines.
so defense is not wanting them to play all of the different videos and stuff of him to verify that it is his account. So he's saying, if we agree to just say we're not contesting that it's his account, can we do that and then avoid going through all of the different videos and stuff to prove that it's his? And she's saying she wants to still show the stuff to prove to the jury that it is his without there being any doubt, beyond reasonable doubt. If Melly is found not guilty, Portland is still going to have to go to trial unless they decide to dismiss the charges. But either way, he's got accessory after the fact as a charge as well. He looks like the dad and stepfathers or stepbrothers from this angle. Let's see. Let me pull up tweets from the courtroom. I don't think Boosie's there. I know Boosie got arrested, so I don't think Boosie's going to be there for. All right, so Mariah Hamilton is the former girlfriend, and she is scheduled as the next witness. Which I guess they were not from what I see, that was not expected from the defense. So now Mariah is the one who he talked to that night.
Again, let the record reflect the president, the defendant, his counsel, and the assistant state attorney, jury, and jury room. I'm not fully understanding everything that you're saying, Mr. Howard. You're telling me that you're not objecting to the Snapchat conversations. You're not going to argue to the jury in some way, shape, or form that it's not him if it's limited to what the state is suggesting, so the conversations between he and his girlfriend and things like that wouldn't come in. Is that what you're saying?
I am saying, Your Honor, that if we need to be able to make an informed decision. So I'm saying that we need to know what she deems to be relevant. And then when we know that, then we can make the decision that, okay, well, we think that it makes more sense to not make the argument that it might not be his account.
Okay.
So that she can get her evidence in, but to get the rest in. Your Honor.
No problem. We'll just leave it the way it is.
Okay. There may be another issue, not as though you don't have enough on your plate here. We have reason to believe that the state intends to call Miss Felicia Holmes in this next session. And there is the law in this jurisdiction and in this state is that a witness shall not be called merely to be impeached. I don't know that that is the case or not, but I'm concerned with trying to unring a bell. The theory is essentially a statement that the state knows that they will not be able to elicit, and they seek to only impeach their own witness by a prior inconsistent statement, amounts to hearsay because it's being offered for the truth of the matter asserted. So when the state calls a witness that they know is about to, and these are instances when a witness says A and then recants and says B, and the state wants to get A in and knows that the witness's current position is B. To put the witness up there to say B and then impeach them with A is improper. I have here some cases, a few, for the court, stand for that position. Dudley v. State, 545 Southern 2nd, 857 Florida Supreme Court, 1989. Felton v. State, 120 Southern 3rd, 126 Florida 4th DCA, 2013. Curtis v. State, 876 Southern 2nd, 13, Southern 2nd, 13, and that's first DCA, 2004, and there are many others. And may I hand up? I have highlighted copies of the cases.
You have first state as well?
I do indeed. If I may.
Take a look, whatever you have.
Thank you, sir. Now, I understand that this might be a little bit premature to the extent that I don't know for what purpose they seek to call Ms. Hamilton, but I don't want to be in a situation where we're trying to unring a bell when we are in a position to avoid that prejudice from occurring. So I'm alerting to the court to that possibility, and if that is in any way the state's intention, I would ask that it be voiced now so that the court is in a position to make that assertion. And they don't even need to voice it to us. They can voice it to the court outside our presence.
And who's your next witness?
Felicia Holmes,
All right, so it is Ms. Holmes? And-
not Ms. Hamilton.
Felicia Holmes, sorry.
And what do you anticipate Ms. Holmes saying?
Judge, I believe she'll testify consistently with her previous statement that she gave in 2018. And I'm very familiar with the case law, and I would agree with counsel that the state cannot call a witness just for the purpose of impeachment. However, I'd also direct your Honor's attention to 9803 subsection 5, past recollection reported, in which a witness who no longer has a memory of an event, but has previously given a memorandum or record as to what happened, they may testify as to lay a predicate as to that, and then that memorandum or record could be read into the record in support thereof.
So are you telling me that you believe that your witness is not going to remember what you said previously?
I believe there are instances in which her memory is no longer available, and that she would testify that she was truthful to law enforcement at the time of the statement in December of 2018, that she now no longer remembers because it has been so long, and that was a time when her memory was better. It was closer in time to the time of the offense. It was within 2 months of the offense occurring and the events of which she witnessed, so that would be admissible under 9803 sub 5.
So you're telling me you've spoken with her, you know, pre-trial discussion with her, and she said she has no memory of what she said at the time.
There are parts of which she does not recall. That is correct.
May I retort? Sure. Okay. A couple of things. One, as with every other witness, the way that you prepare your witness is you refresh their recollection before you call them to the stand. So the notion that this witness is that all the state has been able to glean is that Ms. Holmes no longer recalls something which she said several years ago, and the state has not sought to refresh her recollection, in which case she would have been prepared to testify, then the pretext that she comes in here and says something different, and then she impeaches her with a prior consistent statement, claiming that it's an effort to refresh her recollection, is disingenuous and in bad faith. And if that were able to be done, then this body of law would not exist. We also took her deposition, Ms. Holmes, on December 14th of 2022. No, that's not it. Much more recent than that, no?
2010.
Yeah. December 2022, in which Ms. Holmes receded from the statements to which the state refers firmly and unequivocally. And the state is therefore, I think the language used in a lot of the cases that I have cited and in a lot of cases on the subject is the state needs to be surprised during the course of its examination at the contents of the statement in order to thereafter impeach their own witness. This notion that, oh yeah, well, she forgot, and while we talked to her, we learned that she forgot, and instead of refreshing her recollection, as we did with every other witness that we put forth prior to in preparation for her testimony, we're gonna wait and do it on the stand by impeaching her with a prior inconsistent statement it's a pretext, it's in bad faith, and it's improper. It's prejudicial, and it should not be permitted. Essentially, it amounts to hearsay, because it's a prior inconsistent statement or a out-of-court statement that is going to be used to prove the truth of the matter asserted, which is different from impeachment, where it's not used to prove the matter asserted, it's just introduced to prove that you said something different at a different time. I think these cases are clear. And if that's what they intend to come and do, again, they're inviting error, and I'm alerting the court and the state to it before this miscarriage of justice ensues.
Thank you. Anything else, ma'am?
Just the record's clear in her deposition and counsel, she says, I don't remember or I can't remember approximately 26 times. The witness has been reviewing her statements and depositions for the past 2 days, and she still persists in saying she does not remember, so that 98 or 305 would be an appropriate remedy to enter the testimony from the prior statement.
By the way, Your Honor, I've highlighted those cases for ease of reference. Or at least 2 of the 3.
Felicia Holmes is the next witness, and they're trying to decide if now she's saying that her original statements that she made, now she's saying she doesn't remember. It's been too long for her to remember anything. She doesn't want to say anything.
What's her statement, counsel?
What is her statement?
Right.
This was previously provided to defense counsel.
Oh, just give me a synopsis.
Yes,
What is it that you want, or what you believe she's going to testify to, or if she doesn't remember what you are going to try to refresh her recollection?
So she says that she was woken up at 4 a.m. Her daughter was screaming. The daughter was on FaceTime with Melly. Mr. Dimmons then says he was saying that meaning Mr. Dimmons was saying that someone just shot the car up and was trying to shoot them. He then said there's like a car coming behind them and he's hiding. So then she asks Mr. Dimmons, are you okay? His response was, I'm okay. She then asks him where are Sack and Juvie, the common nicknames of the 2 victims, and he said, I don't know if they're in the car, I think they're dead. So she then says, you think they're dead. She then goes through and describes her actions and conduct. She said that she called his mother, Janie. Oh, I wouldn't go into the contents of that conversation because that would be hearsay. She then describes what she sees, which was her daughter on the phone on FaceTime with Mr. Dimmons. She then says that she's going to come down, and then she describes her and came down to South Florida. She said that at that point she asked and called Mr. Dimmons again, spoke with him and said I'm at my friend Fredo's house. Fredo picked me up, so we went to Fredo's house. Then she describes that Fredo lives over in the same neighborhood that Melly lives in, and that she went in through another gate from the same neighborhood on that one. She then says shortly thereafter in her statement, when they get to Fredo's house, that Melly comes out and he takes Mariah and they go upstairs at Fredo's house. Then she also goes through and indicates that after this incident, that Mariah, her daughter, Mr. Dimmons, Cortland Henry, and Cortland Henry's girlfriend are living together in a condo in Miami. She's going to testify that she didn't, and the statement also says that she didn't see any blood or anything on his clothes or anything like that. The questions asked then about her being FaceTimed, meaning Mariah Hamilton, the daughter of Felicia Holmes, FaceTimed, and Sure answer at that point was, he FaceTimed my daughter from the 772 number. So then she continues on, unless he got rid of that phone, he FaceTimed my daughter that morning at 4 in the morning, yeah. Then she's asked, what's her daughter's number? And she gives her daughter's phone number at that time, 321-506-1313. Then it continues on, and so the law enforcement officer asks and says, I have his phone records, meaning that of Mr. Demons, and he never called, there was never. Then she identifies the phone number as, you have the 772-713-9807 number. She then continues on, he called and FaceTimed with, I talked to him on FaceTime. Then there's another incident, I don't know if potentially this could be possibly admissible, depending on the testimony. She says that they told me there were other guys in the studio, and he was saying that the other guys got mad, but they never said who was at the studio.
But you're telling me, counsel, if you spoke with the witness prior to, and the witness is not saying she didn't say X, Y, and Z, she's saying she doesn't remember
Correct.
The incident.
In the presence of the witness and her attorney.
Thank you.
Your Honor, before I address the specifics there, I just want to put into the record some of the language that I think is most pertinent. In the Curtis case, 876 Southern 2nd 113, which is a first district case in 2004. This is the language. It says Florida allows litigants to impeach their own witnesses, but that does not necessarily resolve the constitutional problem identified in Chambers, which is another case that's referenced. Although a witness may be impeached in Florida by any party, including the party calling the witness pursuant to section 90.608 Florida statute, it is still improper under Florida law for a party to call a witness merely as a device to place the impeaching testimony before the jury. That is Curtis. In the Florida Supreme Court of Dudley, the language that we're relying on, the case says, one major issue requiring our consideration concerns the calling of Robert Bennett as a court witness and the presentation by the state of his prior inconsistent statement as substantive evidence. There's language further down. It says, in a similar situation, the First District Court of Appeals in Austin v. State 461 Southern 2nd 1380 Florida 1st District 1984 found that although a witness's hostility towards the parties may justify the trial court's exercise of discretion in calling the witness as a court witness, to call a witness only to elicit prior unsworn statements for the purpose of proving the truth of the prior statement is error. The district court stated, under the circumstances of this case, it was impermissible to use the expedient of calling the witness as a court witness under section 90.615 for the purpose of eliciting his prior inconsistent statement, either for impeachment purposes or as substantive evidence. To conclude otherwise would permit indirectly that which may not be done directly. Further language from that case says the fact that a witness may be hostile or unwilling does not mean that he is adverse. In order to be regarded as adverse under the section, the witness must give testimony prejudicial to the cause of the party calling it. So if you know that's what's coming in to begin with, there is no surprise. And then in the Felton v. State 120 Southern 3rd 126 4th District 2013, the language that we're relying on, it says, in Ruff v. State 31 Southern 3rd 833 Florida 4th DCA 2010, this court explained Our Supreme Court recognized that consistent with federal precedent, a risk of abuse occurs when a prosecutor calls a witness who was previously given a statement implicating the defendant, but who has since repudiated that statement. In such cases, the purpose of calling the witness must be examined along with a balancing analysis under Federal Rule 403 to weigh the prejudice over the probative value of the evidence. Generally, however, if a party, and that's citing to Morton v. State 689, Southern 2nd, 259, Florida, 1997, that was receded from on other grounds. Generally, however, if a party knowingly calls a witness for the primary purpose of introducing a prior statement which otherwise would be inadmissible, impeachment should ordinarily be excluded. That is exactly what is taking place here. There's no failure of recollection. If the state, first of all, if somebody gets a call at 4 a.m. concerning a murder that occurred, you don't forget it. This notion that she forgot and she is now going to refresh her recollection by reading a statement into evidence that is impermissible, hearsay, is a pretext, and it is a 403 violation, and it is a violation of well-established law in this state that I've just articulated. And if the state was unable to refresh her recollection of such a significant event during preparation, the notion that she is now just going to read the statement into evidence on some pretext is a miscarriage of justice. If she has a witness, she has a witness. If she doesn't, and she knows she doesn't, calling the witness to impeach them by essentially introducing hearsay testimony is improper. The deposition that we took made clear that she she was receding from the statements that she made, and she gave explanations for why she made statements that she made. This is not a situation of failing recollection. This is a situation where they're trying to put in impermissible evidence under a pretext. We object.
All right, anything else? Not state?
Mayor,
So we're gonna bring it in, we're gonna see where it goes. All right, I understand what the objection, God bless. I understand what the objection is. We'll see where.
I thought that was a dog.
Right.
He said, God bless. I might thought somebody sneezing. I thought that was a dog. All right. So this call happened 4.5 years ago, and the mom has said that she saw, her daughter's FaceTime when Melly called, or FaceTimed after this happened, and said that what they just said about how they're victims of drive-by and all that. Then she started saying that she doesn't remember what happened. So they were fighting on whether or not to let that come in. So she's going to come testify.
But those aren't the same statements that we're looking at.
no, these are the phone calls she's going to make.
Sure.
Your Honor, I'm not sure we're ready for the jury. We're being handed totally different information that they plan to
Gary, hold on.
put in through this witness.
I'm sorry, what were you handed, counsel?
Counsel has been handed and was previously provided a portion of the defendant's phone extraction. This particular summary, and there was a notice of intent to rely on summaries filed prior in this case by the state. This particular summary details the conversations between the defendant under the 772-713-9807 phone number, conversations with Mariah Hamilton, the witness's daughter, and her cell phone on that, as well as conversations with Miss Holmes herself, who is a party to some of these conversations. There was a group chat going on in which she is able to authenticate that the phone number, the 772-713-9807, is reflected in those records, was being used by the defendant at times before, after, and during the homicide in question.
I take it these are just being introduced to identify the 9807 phone number
As well
as
as,
being a phone that Mr. Demons used.
correct. So, and if there's two first pages, because if you look at them there's a section in green where he's telling Miss Hamilton this will be his third birthday he's been locked up on. I agree that that would be prejudicial to the defendant, so I created a version in which that specific item is taken out. So if you look at the green birthday and then just take the first page and the second page, or if you look at one another, with the exception of that alteration.
I'm not sure I understand. It sounds like you're saying these are conversations that took place while he was incarcerated.
No. He knew and was made aware he was going to be serving a sentence in Lee County, because that was a negotiated resolution. So instead of saying third birthday I'm gonna be locked up on, WTF, instead I just put third birthday, and then her response on that.
To the extent that Ms. Holmes is not a party to the conversations, she can't authenticate. Now, I understand the state is saying that there are certain conversations which were a group conversation between Mr. Demons, Ms. Holmes, and Ms. Hamilton.
Correct.
Are all of those, do all of the conversations in that exhibit fit that description?
No, she's also identifying her daughter's phone number in this other one.
Identifying her daughter's phone number, Your Honor, doesn't identify the participants of a conversation.
And so here are the other ones in which, for example, there is other participants in which her daughter's phone number is included with the defendant, the 9807 phone number, the manager's phone number, the little brother's phone number, the phone number of Miss Janie King is on there. Then there's the phone number down here as part of the third part, where it is the defendant's phone number, Miss Hamilton, and Miss Holmes, that are all listed on there.
And the state has not articulated a relevance of even establishing Ms. Holmes or Ms. Hamilton's phone number. For what purpose? I think I heard the state indicate a little while ago that there was no record, according to the detective, of this alleged phone call. So it's not as though they're going to say, see, here's a phone call between this number and that, because they don't have a record of it. So establishing the phone number, for what purpose? They might as well establish my phone number. What does it matter? If it can't be tied up, or if it's not going to be tied up to some other record that they have. Saying that we want to put it in to show her phone number. Show her phone number for what? What does Ms. Hamilton's phone number have to do with anything? They can proffer it, but they have not yet articulated it. And there are several phone conversations there that do not involve the witness they're about to call. And for those phone conversations to come in through that witness is just improper. How does she even lay the predicate to that?
Yes, ma'am, I don't know what you're trying to do.
So in terms of authenticating the phone numbers and laying the foundation for when these come in later on, I don't intend to publish these at this point. This is a predicate question that has to be established by this witness to show the phone numbers, the participants, the identity of those individuals, and some of the items in them.
And when you say participants,
Correct.
does she know who the participants are? She's a party to this?
She is one of the parties. For example, one of the specific items that's talked about is the defendant killed a pet. It was a snake that died. She knows and knows who had that snake, the circumstances of how it was killed, so she can authenticate based on the content who was on the other side, who was using that phone. The point of contention is who had the 772-713-9807 phone number at the time of the homicide.
Okay, thank you. All right, so we're going to just see where it goes. You make whatever judgment you think are appropriate.
Okay, so thank
I'm
you.
sorry, something funny?
Pardon me?
Something funny?
Not that you're ruling, Your Honor, I mean no disrespect to you. And I hope you don't get that impression.
Let's bring the jury.
Thank you.
Judge got mad. Yikes. All right, well, this is going to be an interesting witness. I'd be scared of the judge. Like, you know, he's the. It's like when your grandfather gets onto you, you know, and you feel bad. That's how I feel the judge getting on to me. All right, now that we've argued case law all morning,
Jury entry?
Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of the defendant, Dennis, his attorneys, assistant state attorney, the jury. Ladies and gentlemen, I apologize for the delay. My fault. Anybody else, I apologize for that. In any event, I think we're ready to proceed. So, Madam State, want to call your next witness, please?
State will call Felicia Holmes. And you're at this time, the state offers state Triple J, which had previously shown to defense. And your 9803 count 6 is a business record. And request.
Any additional objections, counsel?
No additional objections, but objecting on the ground.
Thank you. To be admitted.
Thank you.
Stage Triple J will be marked stage 61.
61.
61, thank you.
Counsel, where's your witness?
They were down the hall. With your permission, I send you a text message, Ryan?
Yes.
I'm not sure why he's rocking, but they did say it's freezing cold in there. But I also rock. Did Melly win the rocking chair today? Possibly. I tend to rock or sway too a lot of times. It's the ADD in me.
Good morning. Are you Ms. Holmes?
Yes, I am.
Welcome. Come
Hello.
on up here. This is our witness stand. Ms. Holmes, when you get there, what I'd like you to do is remain standing. Raise your right hand and be sworn. You get the first time. Thank you.
Loud.
Raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you should give this case should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your full legal name for the record.
I'm Felicia Ashe Holmes,
Please spell your first and last name for the court reporter.
FELICIA, Angel Health and Safety.
Please have a seat. Ms. Holmes,
Yes, sir.
that microphone in front of you does not move back and forth. It'll just up or down, but not back and forth.
Okay.
You ready?
Yes, sir.
Counsel, you proceed.
Thank you. Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, I'm just, I don't feel comfortable.
Are you nervous?
I feel threatened.
So, Ms. Holmes, I want to start and just talk about who you are.
Yes.
Ms. Holmes, do you have any children?
Yes, I do.
Can you tell the ladies and gentlemen of the jury who is Mariah Hamilton?
My youngest daughter.
And how old is Mariah?
She's 22 right now.
And Mariah, did she have a romantic relationship with someone named Jamell Simmons, also known as YNW Melly?
Yes, she did.
When was she involved in that romantic relationship with Melly?
I think it may be like 2016 or so till maybe 2019, 20.
Okay. Did you have the opportunity to meet Mr. Simmons?
Yes, I did.
What did you refer to him as?
I call him Jamell Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Your Honor, may the record reflect in court identification of the defendant.
Yes, the record will reflect the in-court identification of the defendant.
So in October of 2018, had you met the defendant prior?
Yes, I did.
How many times had you met him in person prior to?
A couple.
A couple?
Maybe two maybe.
Okay. Did you follow him on social media?
I'm not sure. In 2018, I wasn't know.
Did you know if he had social media at that time?
I didn't know. I didn't.
Did you have a social media account at that time?
Yes, I did.
And what was your social media handle?
I'm sorry.
What was your social media name?
My name? For which one?
For Instagram.
Instagram. It's like Glen 258.
Did you have a Snapchat at that time?
I don't think so. If I did, I may have.
What about your daughter? Did she have an Instagram?
I'm pretty sure she did.
Did she have Snapchat?
I'm pretty sure she did.
So I'm going to show you what's been already admitted into evidence as State 61. There's a couple of videos and things on that I would like to ask you to have some questions about.
Your Honor, we'd object as to the predicate being laid for this witness to testify to any of this material.
Thank you. Objection noted.
So I'm showing you what is titled Memories 2018 October 9th, 4:58 UTC, Melly, Montana. Can you see that picture there on your screen?
Yes, I can.
Okay. Who is the female over there?
That's my daughter.
And which daughter is that?
Mariah.
Okay. Who else is in that photograph with her?
That's Jamell.
I want to go here to this image. This is 2018, November 11th, 23:53:26 UTC. Again, Melly, Montana. Who is pictured in this photograph?
My daughter Mariah.
Do you recognize the individual in the back?
No.
Prior to coming into court yesterday, were you shown two photographs of the alleged victims in this case?
Yes, I was.
Were you able to identify them?
No, I was not.
In terms of your relationship with Anthony Williams and Chris Thomas, how many times have you met them?
Maybe Zach maybe twice. Judy maybe once.
And do you know them by their real names?
No, I don't.
How did you refer to them?
Zach and Judy.
Okay. So I want to go forward to some of the videos in this particular exhibit, specifically Memories 2018, October 18th, 2:17:49 UTC. Start with this one. I'm going to.
Our relationship is like maybe the most important shit here.
So the image that is shown there, do you recognize the person in that driver's license?
It's blurry.
Okay. I'm going to show you another video, the next one here.
Right there, you know you come back.
Whose driver's license is that?
That's my daughter.
The conversations and things that on there, do you recognize the voice?
I didn't really listen. I mean, you have to play it again.
Sure.
Our relationship is like maybe the most important shit here.
Do you recognize the person who's speaking in that video?
Yes, I do.
Who is that?
That's Jamell.
Okay. So I want to go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And My geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I did.
And who is she?
Jamie.
Had you met her prior to October 26th of 2018?
Yes, I did.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you to.
I don't know if I did or not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about that early morning hours. Did you receive or hear a phone call or a FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Okay. Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hear my daughter's voice.
Okay. What was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2018?
I read the statement.
Okay.
I don't recall, I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Okay. I want to go, and when you spoke, you remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like, I don't remember their names, but I do remember talking to someone.
Okay, so Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018, I went through a lot during that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. I don't remember what I said back. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Like I said, 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter and take her to jail for accessory after that. I do remember that.
Yes. And in terms of the statements that you made about what happened, you don't have any recollection of that? Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't know.
And so you indicated you hoped you were truthful with law enforcement?
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie on the stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything, I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So Ms. Holmes, with regards to that day, did you lie to law enforcement?
I just
answer. Excuse me, hold on. Repeat your question.
I don't remember.
Excuse me.
Yes, sir.
Only one person can talk at a time, and there was an objection. I just wanted to be clear. All right, you ask your question again.
Okay. So Ms. Holmes, did you lie to law enforcement?
Not that I recall.
Okay.
I don't remember.
Okay. Going forward to the events of that day.
Yes.
When you heard that phone call, where were you?
I'm home.
Okay. Where was home in Cocoa?
Cocoa.
Who else was there at your house?
My kids.
When you heard the phone call, did you hear what had allegedly happened?
I heard that there might have been a shooting.
Okay. Did you see any pictures or videos of anyone that was injured at that point?
No, I did not.
Did you see the defendant on the screen of that video call?
I saw his face, yes.
In terms of the method of communication, do you know if it was a FaceTime call?
I assumed it was FaceTime. I couldn't say for sure what kind of call it was.
At the time of October of 2018 through December of 2018, do you know the defendant's phone number?
No, I don't.
Do you recall today what the defendant's phone number was?
No, I don't.
Okay. In terms of the information and stuff that you have regarding that phone number, was that saved in your phone at that time?
It may have been. I can't remember.
Do you remember what phone number you had?
No, I don't. No, I don't.
So Ms. Holmes, to go back in terms of looking at your statement or any of the other things, refresh your recollection as to what the defendant's phone number was and what you had at that time.
I'm sorry, could you repeat the question?
Sure, you said you didn't remember the defendant's phone number.
No, I don't.
Would looking at a copy of your statement help refresh your memory as to what?
No, I don't think it won't.
Okay, would you like to try to do so?
You have to look at it for you, sure.
She doesn't want to say
And so
anything.
counsel, on for the record, and showing her page 3 of 8.
And I'm going to ask you, Ms. Holmes, to just read this part silently to yourself. And we're gonna start here, this, and through here, okay? Silently to yourself. When you're doing that, does that refresh your recollection?
No, it doesn't.
Your Honor, pursuant to 90.8035, the state would move at this time to read into the record the relevant portions.
Objection, Your Honor.
Can I see, please?
Yes, Your Honor.
Hey, John, it's 12 o'clock. Let's take our lunch and recess. Don't discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case. There's certainly no research, all right? You can take that on your chair. Sorry for the delay. What's that? Let's say 1:30. Thank you.
We just started. We're just getting to.
Ms. Holmes?
Oh, sorry.
Okay, thank you.
Yeah, you called it.
Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant, assistant state attorneys, and our witness. Madam, you want to step outside for a minute? Thank you.
So now they're not going to lunch right now.
We're outside.
They're going to go over some of this stuff and then they'll break for lunch.
Thank you. So what do you anticipate this?
That her answer would start with, he FaceTimed my daughter from the 772 number. Question, yeah. Answer, unless he got rid of that phone. He FaceTimed my daughter that morning at 4 a.m. in the morning, yeah. Question, what's your daughter's number? Her number is 506-321-506-1313. But she may have another number because I changed her. She lost her cell phone and got another number. Her old number was, question, no, cuz, answer. Her old number was 877-9609-321. Question, no. See, I have his phone records and he never called it. There was never, answer. You have the 772-713-9807? Question, 9807. Answer, I don't know whose phone that he called and FaceTimed with. I talked to him on FaceTime.
So assuming that I let this portion in, is this going to be a reoccurring theme that what else are you going to ask her about?
In terms of that, as well as the initial part where she says she doesn't recall what he said verbatim. That would be the part where he's saying that someone just shot the car up and was trying to shoot them. So I asked him if he was okay, where he was, and he's like, there's a car coming behind him, like hiding. He was like, there's some, yeah, he's like, yeah, there's some, I think they're still out here or something. So I'm like, are you okay? He's like, I'm okay. I said, well, where are Sack and Juvie? And he said, I don't know if they're in the car. I think they're dead.
And that's the portion that you're looking to have admitted?
So far, based on her current state of her testimony up to this point.
Is there anything else?
If there's anything else that she doesn't remember on that, for example, the Frito bang or Frederick Givens, is his actual name, aspects of that, anything about the condo in Miami, about the blood on the clothes. There's another part later on where she then describes the conversation again that he said. He just basically said that his friend they just got killed, and that he was like, there was lights coming, somebody's coming, someone's coming. I'm like, are they still out there, you know? Question, answer. It's like I don't know. And I said, we're on our way, just so you know, stay put, we'll come get you. So at this time, I'm thinking he's somewhere hiding in the bushes somewhere from whoever shot him.
And the statement goes on, there's other things that you're trying to get out through this witness that you're concerned that she may or may not remember.
Those are the relevant portions, Your Honor. There's a lot of other things that she indicates in the statement that I would agree would not be relevant, and that wouldn't prove an essential fact that is at issue in this case. So I would not be seeking to insert the entire statement.
Basically, the portions that you just elicited.
Yes, Your Honor. And I can I have the ability to, in a Word document, to isolate those so that they can be succinctly read, provided to defense as well, so they would have copies. But the case law is clear and the statute is clear. The state cannot introduce that statement, but defense would be able to if they so chose.
Thank you. And your objection is?
Your Honor, we have a copy of her deposition, which makes clear.
Can I stop you for a second?
I'm sorry.
What is counsel reading from that? What are you reading from that?
I am reading from her statement of December 12th of 2018.
You're reading from a statement, not a deposition.
Correct.
Thank you. I'm sorry. Go ahead.
Thank you. And before I go any further, Your Honor, I meant no disrespect. And I appreciate your and understand your authority, and you're making decisions. Whatever reaction I had was not intended to convey disrespect, whether I agree with your decisions or not. Her deposition of December 14th, 2022 will clarify the issue of whether this is a failure of recollection that the state is trying to refresh, or whether or not this witness has recanted her statement and is making an entirely different statement about the facts of that night. In this deposition, she is not claiming not to recall. She said she wasn't certain about the time of the call, but she quickly got herself together and came down here, and it took about 3 to 4 hours, like she said, and she got here around 12 or 1 o'clock, which would place that call at 8 or 9 o'clock. There are several other substantive statements that indicate that she is recanting that statement she gave on that day. She says the reason that she gave the statement was because her daughter was threatened with arrest, like she said here. She said that she feels threatened, and the first thing she said there, she's not talking about Jamell, she's talking about the state. She's on an ankle bracelet. They arrested her in the Virgin Islands and brought her over here. And the statements she's making in her deposition do not support and are I wouldn't say they contradict, but they're not the statements that are made in the statement that the state seeks to elicit. If the rules allowed her to put a witness on just to get in a prior statement, then they'd be in okay territory. The rules don't permit that. She's creating this pretext. Oh, you forgot that? Well, let me read it into the record. I would offer the court a copy of this deposition over lunch to review that makes it clear that she is recanting. She is not forgetting. She is recanting. And that's exactly what these cases speak to. And the process that the state is, what they're attempting to engage in is to violate and circumvent the rule and omit out-of-court statements for the truth of the matter asserted, which are hearsay, which are recognized to create constitutional problems, which have resulted in some of these cases in murder cases being reversed, murder convictions being reversed, and she's inviting error into this court, into this trial, and we'd ask the court to at least get a context of what is going on here, whether this is a failure of recollection, whether that's the way she's fashioning it, or whether or not what she said in her deposition does not comport with what she said in that statement that she's recanting, and whether the state is just using this rule as a pretext to get the statements that they're not committed to.
Thank you. You had the statement of Ms. Holmes as well,
I do, Your
and that
Honor.
was taken under oath.
It was, yes, it's a sworn statement from Ms. Oath, from Ms. Holmes in December of 2018. And Your Honor, I would also add that some of the timeframe and issues of that, those were actually clarified because defense provided the state with reciprocal discovery of Ms. Jamie King's phone records, which authenticate the statements, for example, that Felicia Holmes said she immediately called Jamie King. That is shown in Ms. King's phone records,
Who's Jamie King?
the defendant's mother. So there's outside sources that corroborate the sum and substance of her December 2018 statement.
All right, so I'm going to take the statement. If there's no objection, I'll take the statement and the deposition. I'll read those over lunch, and then see everybody back here at 1:15. I told the jury to be back at 1:30. We'll resolve those issues, and we'll move forward. All right?
Thank you, Judge.
Thank you.
Okay, so they are going to review this and see what they're going to be allowing in. The thing is, she is one of the ones who, you know, she gave a statement and a deposition. So, and she said that, you know, that she saw his face, and that the original statement, I think, was that he called, or he FaceTimed Mariah answered it, and he told her about the drive-by, and she like screamed. So when they were asking her, well, what was her tone of voice like? What was her emotion like? She said, oh, I can't remember. But in the statement and the deposition, it said that she screamed. And that's what woke her up. Let me mute this because it's about to get loud. So the, you know, a big part of them putting the story together is, you know, some of her testimony that she gave about the call at, you know, after 4 a.m. where he said that they were just in a drive-by, and, you know, what he said, and, you know, they asked about seeing blood on him and stuff like that. So they are going to review that, and then I guess we'll find out when we come back from lunch if they're allowing in parts of her deposition or parts of her statement, or if none of it's going to be allowed because all of a sudden now she can't remember anything. So I guess we will see what they do. I'm going to put a timer up. Oh, my dogs. Oh, that's not my dog. My dog's beside me. Let's see. So we've got an hour and 20 minutes until lunch. I am going to take a little break, and then I'll come back and we can look stuff up and answer questions and any of that stuff that you want. Let me share my screen. Let's see. Present. Yeah, the GSR stuff. That's, if y'all remember when they were talking about it yesterday, when he said he was questioning about the GSR, and he said something about it being negative on the presumptive test, but then it turns out it came back positive in the lab test. But that's part of why they use it for like a screening purpose and not for like a end all be all, I guess I should say. All right, let's see. I've got this up, I think. A little timer. Okay. It takes me so much longer when I can't see what I'm doing. It's the laptop. I'm all thrown off not being at home. Okay. I've got the timer pulled up. So we will be back in just a few seconds or minutes, not seconds. And I think JT is going to get y'all some music to keep you company, jam out to. Let's see. Start our timer. There we go. All right, I'll be back.
we might as well rock and roll.
cuts from 1,000 knives I recall. But I'm still stumbling in the darker, silent hour as I dissolve into your arms. I waited now, seduced by a sweet mirage. We could leave or we could stay, stay to wide awake. I can't do this anymore, it's hurting like it never has before. We could leave or we could stay, stay to wide awake. I can't do this anymore, it's hurting like it never has before. Jaded, the scar you left feels like an open wound. I'm down and low. Don't wake me up, it's still too soon. I hear you call, but I'm still falling deep in love. I'm washed away and carried to your sweet embrace. I waited now, seduced by a sweet mirage. We could leave or we could stay, stay to wide awake. I can't do this anymore, it's hurting like it never has before. We could leave or we could stay, stay to wide awake. I can't do this anymore, it's hurting like it never has before. And it's hurting like it never has before. Fading slowly into the silent night, an endless fall, like cuts from 1,000 knives I recall. But I'm still stumbling in the darker, silent hour as I dissolve into your arms. I waited now, seduced by a sweet mirage. We could leave or we could stay, stay to wide awake. I can't do this anymore, it's hurting like it never has before. We could leave or we could stay to wide awake. I stand up against the wall so I can trace you with one fine line. We have become a home that's built of all your poems and mine. Please don't disappear. It's not what you think it's gonna be like, but nothing ever is in this life. It's a slow dance in paradise. When the world's on fire, look for my eyes. I know you wanna go, and I don't blame you at all. I'm learning my own skin in reading what you wrote back then. Please don't disappear. It's not what you think it's gonna be like, but nothing ever is in this life. It's a slow dance in paradise. When the world's on fire, look for my eyes. Look for my eyes. Look for my eyes.
I think if she said that she did, that would be suspect. I think so. In terms of having a better memory back in 2018, 2 months after the incident or less than that, that is valid, and that she had said she was truthful with law enforcement at that time. So the state has met the admissibility threshold on that particular issue.
Thank you. And what says the defense?
Your Honor, I think the state undercuts its argument by admitting what she perceives to be the case, which is that concerning the gravamen of what she's trying to introduce, she believes that the witness is feigning a lack of recollection. In other words, she is recanting. So this is not And what's important to realize is this is not about determining whether we have a witness who is being honest or not. I think this rule contemplates a witness who may be being dishonest by recanting. And the issue is not whether or not the witness is being dishonest, and in the interest of justice, we want to put in what we believe to be a more honest statement. The question is whether or not you're putting up a witness to impeach them. Putting up a witness to introduce a statement previously made from which that witness has receded, or which that witness has recanted, which is what's going on here. And the rule is clear on that. Can't do it. It's hearsay and it should not be permitted. Any issue with respect to whether or not the statement is sworn or not, I think sworn statements typically contemplate an adversary having the ability to test credibility at the time it's made. Furthermore, this witness, when asked by the state, did you give an honest statement to law enforcement back in 2018? She's like, I don't know that I did. She posited the possibility that she could have been lying then, which further undercuts the indicia of reliability. She also said she felt threatened then because she was speaking, given that she was advised that and I think advised in bad faith, that her daughter might be charged as an accessory after the fact, when there was no evidence to suggest that. And she said she was acting then under threat and that she's not certain whether she was being honest then. So for the state now to say, hey, she's having a failure of recollection, so we just want to read her prior statement into the record, is a pretext. And it runs in violation of the law in the state of Florida as explicitly outlined in the cases we cited and numerous other cases. So that's why we object.
Thank you. So, counsel, I've looked at a couple of cases that came across. First is 880, 880, 561 Pierce v. State, Supreme Court of Florida. And the second, 993, 1108, 4 PCA case, SL versus State. And in the first case, the Pierce case, that was an issue whereby during cross-examination of a state witness, defense counsel had asked whether or not the witness had previously told detectives and that he made a statement and expressed surprise at some piece of evidence. And the state, his response was he didn't recall, don't remember, something along those lines. And the end result was that the Supreme Court said in order to resolve this claim, I'm reading from the 8th page of the opinion, it said in order to resolve this claim, you must examine the law relating to the admissibility of prior inconsistent statements. Prior inconsistent statements are not hearsay and can be admitted as substantive evidence. And quotes, if the declarant testifies at trial or hearing and is subject to cross-examination concerning the statement, and the statement is inconsistent with the declarant's testimony and was given under oath subject to the penalty of perjury at a trial, hearing, or other proceeding or in a deposition. Then it goes on and says this court has held that a statement given under oath during police investigation is not a statement given at an other proceeding and consequently is not admissible as substantive evidence. The second case I have is SL be stated, as they said, 9937 1108. And that's a little more succinct. And at the second page of the opinion, it says, in order to resolve this appeal, we must determine whether the statement made by SL's mother to the deputy were admissible as substantive evidence. The Florida Rules of Evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at trial, hearing, or other proceeding, or in a deposition. It goes on and says, interpreting this provision, the Florida Supreme Court recognized that a statement given during police investigation is not a statement given at an other proceeding, end quote. It doesn't appear to me that that statement is admissible as substantive evidence, counsel. So what the end result of all of this is, if you ask the witness guys remembering the statement and you want to read it to them, I don't see how a curative instruction telling a jury it's only for impeachment purposes and not as substantive evidence is going to resolve it. So my thought would be just to keep it out. So I sustain the objection.
So just so it's clear, it is not a prior inconsistent statement. So the line of case law that you cited would not be applicable. It's a past recollection recorded, which is a very specific subset. So I refer to Earhart on that specific issue, 9803 sub 5.
Excuse me one second. Could you get it right here? I left it on my desk.
This is a big part of this. Her statement is huge because she's, saying that, well, she doesn't want to say anything now, but her original statement was that she saw his face on the FaceTime, and that, and what time it was around 4 a.m. and what he said about being in the drive-by. So this puts him in the car when they were killed. So it's a huge piece that they're trying to get in. Well, but now she doesn't remember anything. And she said she feels threatened. They arrested her because she didn't want to go give a deposition. They arrested her, so she had to go give her deposition.
No.
I don't know if they've let her come back in or not yet. Or somebody's going to get in trouble for their phone. No, they did not arrest her today. This was when she was doing her deposition, or when they wanted her to do her deposition. They could not be any louder. Really. And that was what, like, after this happened, like November, December, I think.
I'm sorry, Counsel, what section are you talking about?
9803.
In Earhart.
Yes, subsection 5, 98035, which in the 2022 edition starts on page 1104.
So he made his decision, and she's saying that the case law that he cited to make his decision is not the same as what she's saying is the case for this one. Because he made a ruling based on cite law or citing case law that was about previous inconsistent statements, and her statements were not inconsistent before. She's just saying now that she doesn't remember them. So now they're re-reviewing it. I don't know how she gets her hair so shiny. Let's see. I can hear them whispering a little bit, but Holly B says, the Melly fans are certain of his innocence. I'm not so sure. Will be interesting to see the evidence if we ever get to it. Yeah, my mind is still open. I mean, the evidence against him looks, it's all circumstantial, but it looks pretty bad when you put it all together. But we'll see what the defense is and how they explain it, or because remember this whole first part where it's prosecution
Defense and a copy for your honor.
is all the evidence, and then we hear the defense. We have to hear the whole defense before we can make up our mind for sure. But everybody's gonna be leaning one way or the other, of course.
116,
Let's be nice.
270, Florida Supreme Court, 2013.
I think it's going to be hard for them with her showing the other case law. I'm curious to see what he says, but you know, for her to give deposition under oath, and she's not saying that she lied now, so she's not being inconsistent now. She's just saying that now she doesn't remember. The jury is still out. They're not coming back in until they make the decisions on what he's going to consider admissible. bet they are sitting there reading chat. That's one thing that they have mentioned too, that it says at the very end, 4 days after filming ended, that Melly and his friends were victims of a drive-by. So that is putting that was putting him at the scene too. So that's on his YouTube. See if we have any updates from the courtroom. There's no recent updates. There was an update that Felicia Holmes, who got off the stand right before we went to lunch, Mariah's mom, hugged Melly's little brother in the hall on the way to lunch. That was the last update. For those joining us, we are still waiting for the judge. He's reviewing case law, so we're waiting to find out what he's going to allow in from Felicia Holmes. Like, now we'll know if he's watching. How funny would that be? It happened when I was like, oh my God, he's touching his ear. That's funny. I see the question, where's the driver? The driver is out on bond, and he has a hearing in July, and then he's scheduled to go to court October, I think, 2nd. His charges are murder in the first degree and accessory after the fact. Sneeze if you see us. I know, I keep trying to listen, thinking I'll be able to hear something, but I can't hear them. Yes, the jury is, there's 9 women on the jury. And they said, I think he said there's 6. Well, let me see. He tweeted, there are 9 women on the jury. There are 6 Black men and women on the jury. The jury is death qualified. So 9 women, 3 men, and 6 are Black, he says. I don't know. The tweet said this morning that when somebody came up and asked who she was, she said that she's the boss. That's all. Thank you, Elizabeth Evans. Thank you. Thank you. I appreciate that. Elizabeth Evans says, today is payday. Share the love. Brandi, you and your mods are incredible. Love being a part of the family. Our mods are incredible, and we're glad you're part of the family. I appreciate that. Thank you so much. Yeah, we heard this a lot yesterday too, that they remind us of Letitia and Backpack. Yeah, we're waiting on the judge to make a decision. She is, oh, where did that go? The prosecutor submitted new case law about the admissibility of the statements and the deposition made by Felicia. So the judge is going over that because he made his ruling based on case law that she said didn't actually apply to this. So that wasn't the same thing. So he's reviewing now. Let's see. Ricky Watson just gifted 5 memberships. Thank you so much. Let's see. We have another tweet. We have P.I. Lisa, Jeff Williams, Tiffany Carter, Kelly J, Cindy's Crazy. We're all gifted membership by Ricky Watson. Thank you, Ricky. The latest tweet says that both Melly's little brother and Felicia have yet to return to the courtroom as we await trial to resume after lunch. The courtroom is dead silent. Oh, except for the squeaking. What's interesting is that this is a big part of how they came up with their theory and stuff. And I mean, there are still other things, like his location data is still going to, on his phone, is still going to put him where it puts him. But them seeing him and testifying that they saw him, it's putting him at the scene of the crime. So it's kind of big stuff they're fighting over. But the defense attorneys are doing a great job. I mean, there's a lot of things that not one of them is like one of the slam dunks. This is, the deciding factor, but there's a lot of it together. So the defense has taken each part of everything that's being presented as evidence and trying to poke holes in it. That's what they do. Well, it's not a video that he sent her about the drive-by. It was him on FaceTime.
Anything else you wish to share with me, Counsel?
Yeah.
How about from the defense? Anything else?
A commentary on the case that was just provided.
Yep.
The polite case, the very first head note, says that the admission of the past recollection recorded under exception to the hearsay rule requires the witness to indicate that the statement was made at the time when the events were fresh in her mind, his or her mind.
That's done.
And also attest to the accuracy of the memorandum or record. The opposite of that.
Excuse me. And that's in the bottom as well. That you're reading the head note.
Yes.
I just highlighted the portion at the end. It says, we reject the 5th District's embrace of a totality of the circumstances test and affirm that in Florida, the admission of past recollection recorded under section 98.803 subsection 5 requires that the witness indicate that the statement was made at the time when the events were fresh in his or her mind, and also attest to the accuracy of the memorandum or record. Then it goes on in conclusion. In this case, a proper foundation for admission of the witness' statement of past recollection recorded was not established. As we've explained above, the hearsay statement was inadmissible because the witness did not vouch for its accuracy or correctness.
That's something further.
Counsel, my thought is this. If what I heard her say previously was that she couldn't vouch for its accuracy or something to that effect. If that's what she continues with, I'm not going to allow you to admit the evidence. All right,
Understood.
so, are you ready to proceed?
Yes.
All right, let's bring the jury. You're ready as well? Max, you ready? Yes. All right, bring the jury. Yep. Bring the witness in, bring the jury in.
Grab the wood.
So she gets up there and says that she doesn't think that, or she can't vouch for her statements being accurate, then they won't let that in. I mean, if this were a movie, this is the point where we know that, like, everybody's like, oh, yep, they got to them. There's not even a little part of me that believes that she actually forgot, but I think she doesn't. She doesn't want to get involved.
While we wait, can you go sidebar briefing?
Yep.
Oh, gracious. I know what that knocking is. I know he's knocked on the table a few times for whatever reason. Notice that. The thing is, it doesn't matter how much she says that she doesn't remember now. She was, when her statement was given, it was a lot closer to when everything happened. So her not remembering now isn't the thing. It's her, if she says that she can't validate that her statement was accurate at the time, or her deposition was accurate at the time. If she can't testify that, you know, what she said then is true, then, or accurate, then they won't let it in, which is what defense is trying to do. And you can tell that when they asked her, she said she didn't say, you know, anything about being honest or what. She said that she hoped she would have been honest. This is interesting. I haven't seen a witness like this before.
Jury entry.
Juvie's grandmother is upset that Felicia is wearing all white. She said she's a liar. That's what the grandmother said about her.
The record reflecting the presence of attorneys, defendants, as counsel, deceased state attorneys, ladies and gentlemen, jury, are witnesses. Felicia Holmes remains on the stand. Ladies and gentlemen, I apologize for the delay. It's my fault. In any event, I think we're ready to proceed now. Ms. Holmes, I just remind you, you're under oath. All right. Thank you. Proceed, counsel.
Okay, so I want to talk a little bit about your deposition.
Yes.
Do you recall, and you've been provided a copy of that deposition?
Yes, I got, my lawyer got provided a copy.
When you, in that deposition, were you asked if your prior
Objection.
statement?
Improper impeachment. I heard it over. You can ask your question, counsel.
Ms. Holmes, prior to that deposition starting, were you given your prior statement to review?
What you mean?
Were
I
you?
understand, the position that I did on December 22nd? Yes, it was given to my lawyer yesterday, right before, briefly to look at, yes.
So the deposition you that was
It was given to my lawyer
provided.
yesterday, yes, it was.
So do you remember coming into that deposition?
Yes, I do, I was in jail, good in jail.
Correct.
I remember.
And so it's clear in terms of you don't want to be here.
You're making me be here, yes, I have
Yes.
a house, a band on my leg, I'm a nurse, I can't even work properly, yes.
You were under house arrest because you failed to comply with the subpoena?
No, you did not serve me.
Excuse me, sustain. Listen, how we're gonna do this is you ask your questions, counsel, ma'am, listen to her question, answer her question.
Yes, I am.
All right?
Yes, sir.
Thank you.
Okay. So going back to the deposition.
Yes,
On December 14th of 2022,
yes,
do you remember coming to my office?
yes, I do,
Do you remember being asked questions at that time?
yes, I do.
Do you recall being given a copy of your prior statement of December 12th, 2018?
No, I don't remember that, I don't remember that, but I'm pretty sure I did.
Okay, so what I'm going to do is permission to approach her on it,
With what, counsel?
her deposition.
Objection, Your Honor.
I have given an opportunity to.
I saw that.
Excuse me, there's no question pending review. All right, you can proceed, counsel.
Okay. So, counsel, I'm showing her page 10, line 10 through 17. Okay, so just read them silently to yourself. So back on December 14th, 2022, were you asked if you need to make any corrections or deletions to the statement of December of 2018?
That's what the deposition said, judicially.
And did you indicate that there was no corrections or deletions in those statements?
I don't remember, but that's what's on the deposition.
So December of 2022, you said that this was a correct statement.
Objection.
Sustain.
So Ms. Holmes, is the December 2018 statement that you gave correct and honest?
Objection. Ask and answer.
Excuse me. You have to I understand you're trying to answer the question, Ms. Holmes, but when they raise an objection, let me answer the objection first.
Yes,
all right?
sir.
Objection notice overruled. Question is the statement, can you repeat your question?
Is this December 2018 statement correct and honest?
I don't remember the December 2018 statement.
In December of 2022,
Yes, ma'am.
did you state that it was an honest and correct statement?
That's what you put in the deposition. I don't remember saying it, so I can't remember verbatim what happened that day. I remember some parts of this deposition, but not all.
Okay, is there anything that you need to refresh your recollection to determine whether or not I'm being truthful and accurate as to what the question was in your answer?
I don't know to say that.
Okay.
Is that a question?
I've asked if there's anything that
Excuse
was
me,
told.
one at a time. I just wanted to let her finish her answer before you ask the next question.
So, Ms. Holmes, is there anything that would help refresh your recollection?
I don't think so. I don't know.
Would the audio of the statement of December 2018 help?
Objection.
What's the objection?
It's irrelevant. She testified 3 times.
Excuse me, thank you. Not as to this, go ahead, overruled.
I don't know. I don't.
So, Ms. Holmes, with regards to the events of October 26th of 2018,
Yes, ma'am.
did you travel down here to Birmingham?
Yes, I did.
Who did you come with?
My daughter Mariah.
Okay, where did you go?
We went to one of Jamell's friend's house.
And whose house was that?
Frida.
And now approaching has been previously shown to defense counsel and marked as states triple N for identification purposes only. Ms. Holmes, do you recognize the 2 individuals in that photograph?
Yes, I do.
How do you recognize them?
I know Frida from being on Instagram from rapping. He's a rapper.
Okay, any other individual in that photograph?
My daughter's with me.
Okay.
I'm sorry, I apologize, I didn't hear that.
I'm sorry.
I didn't hear your answer. Could you
Which
repeat?
one? Do I recognize?
Thank you.
I do recognize Frida from Instagram for being a rapper, and I recognize Jamell from dating my daughter.
Your Honor, at this time, state we request to move states triple N in as the next covered exhibit.
Any objection?
Relevance.
Overruled. It'll be admitted.
States triple N, be marked states 62.
So Fredo is rapper Fredo Bang, and he's the one that Melly sent the location pin drops to after the shooting. He sent them 2 of them 11 minutes apart.
This is the photo that you can see on your screen that you just identified? Okay. So when you said Frito, is this the individual's house you went to?
Yeah.
Okay. Ms. Holmes, how much money has the defendant's manager given you since the October of 2018?
Objection. Relevance.
Watch from sidewalk.
Dang. Interesting. So they made the decision that they're not going to let her stuff come in if she can't say that it was accurate. But she wasn't in there when they made that ruling. So she doesn't know that, you know, she doesn't know basically what they're looking for in order to determine whether or not her stuff is going to be let in or not. Yeah, the how much money she's gotten is that was a big one, big question. We could do a poll on it. I don't think anybody actually believes she forgot. I think she didn't want to get involved, but some other people might think differently. Let's see. We'll do a poll. Do you think she really forgot? No arguing over it, no being mean, just opinions. Do you think? Miss Holmes really forgot everything? Okay. Let's see. Yeah, Shireen, tell him if you press the wrong button, you're in timeout. Nobody ever presses the right buttons. Not nobody. But let me say this. There's never a poll where somebody didn't say, oh, I pressed the wrong button. Okay, let's see. Newest tweet from the courtroom. A female juvie family member said, shots fired. The prosecution submits an evidence photo of Melly and Fredo. The tension in the courtroom continues. Let's see. think that's the only other one. That one's I think we read. He said, "Oh, correction. His little brother was in the courtroom." I think that's all. I think the rest of them I've read for y'all. See, they're taking a long time on this, but this is such a huge, huge piece of their whole prosecution, their whole case against him.
Okay, so I'll ask again. How much money have you gotten from the defendant, Jamell, and his manager? And with regard to that specific statement? Ms. Holmes, you have formerly had a credit union account?
Launch credit union.
Okay. And at Launch Credit Union, you banked there for a number of years?
Many years.
The credit union that you've been at, it's been your account, and I won't put your account number on the record for that reason.
Your Honor, object to this line of questioning based on this court's ruling.
So your testimony is that you have never been given money.
Uh-oh.
I've never been given money for personal use.
Okay. So the question is, how much money have you been given by the defendants?
For vacation for all of us, for him, his wife, and me to pay for it. As far as he gave me $5,000 for Airbnb, and I gave him $1,000 to deposit that.
So he did give you money?
Not for personal use.
Okay.
Excuse me, can we clarify who he is, Jameson Francois?
Objection, or just clarify, counsel.
So it's clear, who is Jameson Francois?
He's trapped, he's Nelly's manager.
And you mentioned his wife as well. Who's his wife?
I used to go by AA.
So AA and his wife.
We were all good friends.
Okay. So I'm going to go now with the previously shown to defense counsel and marked as states triple M. It's a composite of 17 pages. Did you have an opportunity to review that prior to coming into court today?
Yes, I did.
Okay, and in terms of the individuals and the phone numbers that are on that, do you recognize your own phone number?
No, I do not.
Okay. Going forward to the contents of that particular item, do you recognize the conversation about a snake?
No, I do not. I know they had a snake, I don't recognize this conversation.
Okay, with regards to the conversation about the snake that you do remember, what do you remember about the snake?
That they had a snake.
What happened to it?
Objection, relevance is sustained.
Aaron, may we approach that?
Sure.
Another sidebar. So she said she had never gotten money from his side. And now they talk about bank records, and I guess she did get money from somebody. So now they're having them clarify who from how'd she word it? The defense side or something like that, or the defense, I don't know. So now they're wanting to clarify who is the actual one who sent her the money. Let's see. She said Yeah, but their problem isn't, it doesn't matter what it was for. They asked if how much money she had gotten from them, and she said none. So, but then when they talked about her bank accounts, and she said, well, she did get that. I kind of like, my personal opinion, I think she's out there lying. She doesn't want to testify, doesn't want to get involved, whatever the case is. She said she feels threatened, and that's why she's there. I don't know if she feels threatened to go back to jail because she got arrested the first time and she wouldn't give her a deposition, or if, she feels threatened by, one side or the other. I'm not positive about the snake. Is that the rumor about him killing a snake or something? But I've only heard it as a rumor. I've never verified anything, so I have no clue to its validity. Welcome back, Julie F. Yep, they're still arguing about what's permittable. They're over the Snapchat stuff now, though. Now they're on to her deposition and all of that. Yeah, they asked her if there's something they could give her to refresh her memory. Because normally, if, you see a witness up there, they're like, okay, well, would reading what you said refresh your memory? Yeah. Would seeing this video refresh your memory? Yeah. And they're like, okay, well, would the audio of literally what you said refresh your memory? She's like, nope. She don't want to hear it. She don't want it played. She said it was for an Airbnb, I think, that he gave $5,000 for an Airbnb and she gave back 1,000 of it or something like that.
So Ms. Holmes, I want to ask you a question as to what was your daughter's phone number back in October of 2018?
I have no idea, I don't know.
Is there anything that would refresh your recollection as to what her phone number was?
No, because I don't remember mine.
You don't even remember your own?
Yeah, no, I don't know.
In terms of, did you review your statement of December 12th of 2018? Did you review that statement prior to testifying today?
Yes, I did.
And in that statement, were you asked, what is your daughter's phone number?
Objection. I don't remember.
If I were to show you the statement, would that help refresh your recollection as to whether or not you were asked that question?
I don't think you would, but you can show it.
You have permission to approach?
Yes, ma'am.
Okay. 3 of 8. If you could just read silently to your son. Okay, looking at that, does that refresh your recollection as to what your daughter's phone number
I
was?
still don't recognize the number. It doesn't believe, I don't know if that's her number. I don't recognize the number.
Okay, so you don't recognize the number?
Yeah, I got 3 daughters, so I don't know.
Understood on that one. So, Judge, permission to treat the witness as hostile?
Objection. What's your sidebar, please?
It's frustrating because they can't even really treat her as a hostile witness technically because she's not even testifying against the prosecution now. She just doesn't want to testify. She doesn't want to say anything. She doesn't want to be involved. She wants to go home and be left alone. But I mean, they've got her bank records, so they'll, if this continues, then that's what they'll show, that she received money for whatever reason, that she received money from them, and then that's going to make it appear that that's why she doesn't remember things anymore. If they don't allow in her original information that she gave about when she had to go do her deposition, if they don't allow that in, then that means the jury will never hear that she said that, they'll never hear her say that she, saw his face on the FaceTime and that she saw him because her daughter screamed when he told her about the drive-by and all of that. They won't hear any of that. This is Mariah's mom. So she was there when he, there were statements from her, from Felicia and from Mariah that Melly FaceTimed them, or FaceTimed Mariah, and they both saw him on the phone talking about he was hiding, waiting to be picked up because they were just in a drive-by and he thought that Juvie and Zach were dead.
Ladies and gentlemen, I need some time with the attorneys. Please, as you go to jury, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case from your presence and certainly your research. Please no feds on your jury.
Here we go again, sending the jury out.
Thank you. Let the record reflect the jury stepped out. Counsel may, along with the defendant, witnesses on stand. Ms. Holmes, my understanding from council side is that you have an attorney here with you, is that right?
Yes, I did.
No, I was told to bring him in here.
Might be a good time for you to talk to him. So, you want to speak to your attorney, any objection to that? by the way?
Yes,
What's
yes,
the
Your Honor.
objection?
The witness is on the stand, and for the state to suggest to a witness who's already been sworn and is in the middle of testimony that she goes and talks to her lawyer, it's type of intimidation, coercion. I think the rules have been. So we do object to that. It's intimidation.
Well, let me ask you this. Is it something you think you need to talk to your lawyer about?
I'll talk to her. I don't think I need to, but I don't know what the problem is. I'm answering her question like she wants. I'm not sure what's going on.
Well, so my question to you is, do you want to talk to your lawyer?
Yes, I will talk to her.
All right, so we're going to be in recess. You talk to your lawyer, and you go ahead. You step outside, all right?
Okay.
And I'm going to continue with the argument here with the attorneys.
Oh my goodness.
So I guess this is the concern I have. You're asking me to declare her a hostile witness. So here's the mission is.
There you go.
Well, this was your position on it. She's at. That would.
This is good.
Ask these legal questions as she suggested sidebar. The problem with any of the questions, though, I don't want you to be asking specific questions that things that she said previously she doesn't remember, and that you're just going to go ahead and put testimony before the jury. I mean, that's, it's not the attorney's questions that are in evidence. I mean, if she doesn't acknowledge it, or even after asking leading questions, she's basically saying, she doesn't know, or that's the end of it. I mean, you can't go much further than that. You can't put in evidence. Didn't you say X, Y, and Z to the police officer? She's not acknowledging she said it. I can't see how you do that. You can't.
So I think I can ask the questions because
What question?
in terms of, did you provide this phone number as the number for your daughter? Did you provide this number for the phone number regarding Mr. Dennis? Did you provide this information?
What information?
Whatever the particular statement may be that we're at that point in the questioning. For example, did you provide the phone and say that previously that you talked on FaceTime with the defendant? That you talked to him on the FaceTime on the 772-713-9807 phone number? So judges, in terms of if I'm going to then impeach her with some other outside statement or some other prior consistent statement that she has made at some other proceeding at that point, that's the concern as to her perjuring herself on that. So I think that's why it's important that she be allowed to speak to her attorney on that issue. And in terms of the prior statement on that, I still maintain that she has endorsed its authenticity and accuracy. Your Honor was provided with a copy of that deposition that the state referenced when we were talking about, and she indicated she was honest and truthful in that deposition, and she then endorsed the prior statement. So the prior statement should be allowed in on that, and if there's no concern as to any improper or anything on the jurors, because they will be instructed, as they always are, that no statements by the attorneys are evidence.
Mr.
Yes, please. Your Honor, first of all, the state is now conflating issues. What we objected to and alerted the court to because we knew that this debacle was going to take place. I think it is evident that, yes, it appears as though the witness is not a major fan of the state. That's true. The state knew that going in. This is no surprise. These cases use the very language, surprise. In other words, what the state intended to do under a ruse at 803, 90.803, section 5 ruse, is put on the witness to impeach that witness for that sole purpose of impeaching the witness, to introduce an out-of-court statement that is inadmissible because the state understood that she recanted. The state, under the pretext, oh, we don't know that she's hostile. We just think her recollection is failing. And we believe under 90.803 subsection 5, we can just read her statement in. Unfortunately for the state, the Supreme Court has made it extremely clear that that witness has to vouch for the accuracy of the statement at the time it was made. And the Supreme Court also said in that context that in the context of an 803.5 exception, the contents of the record substitutes for the witness's testimony. This means that the reliability of the assertions rests upon the veracity of a witness who is present and testifying. The state is calling into question her veracity and calling her pretty much a liar, saying that she's feigning recollection and now attempting to essentially introduce a report of a police statement into evidence by the state testifying, asking the court to let the jury know that all this stuff that we're about to say, upon which we want to rest our case, is don't take it from me because I'm just a lawyer saying it, but then there's no point in saying it because there's no way to get it through. Because there's no way to get it through this witness. She can't put her on to impeach, which is exactly what she's trying to do. The 803.5 is a ruse, and that's not working out, and now she's doubling back to the original, which is let me call her hostile so that I can lead, and instead of eliciting the testimony from her, I'm gonna read it out of this report and say, didn't you say that? So what happens is we're gonna now be in a situation where she's asking the state to tell the jury, hey, what the lawyers say is not evidence. So it doesn't matter that this witness is going to say, I do not remember that number that you just read to me. That you just let me see. I told you I don't remember it. So I now the state wants to come back to the podium and blurt that number out. She just said she doesn't recall it. So what's the point of saying it other than to introduce it into the record through the state attorney's lips? The rules don't allow her to do what she's trying to do.
Thank you.
So you're in further support of treating a witness as a hostile witness. This has previously been provided to defense, but this is the Instagram production for Miss Felicia Holmes that I'm showing the court now that she has previously identified as her specific Instagram, and that it is saying the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies. They didn't want us talking with prosecutors, but now they have all disappeared. I quit my job based on what Track and his wife or company said. Now look, we can't go home. We're spending all my money I worked for and they taking trips and enjoying life. If you think I was a beast before, wait until this trial. I'm not holding anything back. I'm doing what I should have done in the beginning. They can call me Miss Snitch Bitch. So Judge, it's very clear from this record that my intention and what the witness has represented to me in all shapes and forms that she was going to be honest and truthful. So to say that it's improper for calling her just for the purposes of impeachment is incorrect. So to continue on in that same Instagram production,
wow.
This is in June of 2022. Felicia Holmes is saying, they made me quit, told me that they would take care of us until trial was over. But guess what? Lies as usual. I was making $9,000 weekly. I didn't need shit from them, but everyone begging and pleading. Now they all ghost. I got something for track though. He lied to me and my child for the last time. Again, saying you're going to air him out to the prosecutor. So Judge, in terms of, so that's in defense of the representation of counsel that is just being called for impeachment. It's also clear that this witness has received multiple benefits from the defendant based on her own statements there, that she has endorsed that that was her Instagram on that.
So, counsel, there's a couple things going on here. Number one is you indicated that it was the testimony was going to be admitted because it was in essence, I forget the statute number.
9803 sub 5, it's a past recollection reported.
Past recollection recorded, and you gave me the polite case.
Yes.
And that indicates that you have to have a proper foundation, but it has to be not only there's a proper foundation, but it has to, the hearsay statement was inadmissible in that case because the witness did not vouch for its accuracy or correctness, which is what we have here. The witness isn't vouching for the correctness or accuracy of the statement. So it doesn't meet that criteria. On the other issue about impeachment, this is not what she said. She's, she said, gave me a different answer. What I tried to read before was something from a couple of cases. And again, the synopsis at the end of it, I'm just reading again from the SL, a child case, v. State 993 Southern 2nd 1108. It just says the Florida rules of evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at the trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. Goes on and says, interpreting this position, the Supreme Court of Florida recognized that a statement given during a police investigation is not a statement given at and other proceeding. So then if you agree, I don't know where we're going with this, counsel, respectfully. It seems to me under either scenario, that statement doesn't connect. Now, I do have a message from Mr. Bears, B-E-R-E-S. He says he's Ms. Holmes' attorney. He would like to speak with me. I don't know what he wants to talk with me about. He can't agree, I'm assuming it's this testimony. But anything he could say right here in open court, I don't have an issue with that.
That's fine, Your Honor. I really question the purpose in advising my client, Ms. Holmes, to consult me for a lawyer. I take it as an implicit threat to Ms. Holmes. We have an agreement that she comes in here today to testify. She's done that. She's honored her agreement. And, she's answered all the questions put to her. She may not be answering the questions to the satisfaction of the state, but she has fulfilled her agreement. And now Ms. Holmes is again placed in fear. And that's all I have to say.
Thank you. All right, let's, anybody need a restroom break, Brandi? You ready to go?
Yes, sir.
Pardon me?
Judge, I think someone on the fence.
I need to go to.
Sure. We'll take a short recess.
So that just took a big turn. That's not something I've heard before. That's not something I've seen in any of the discovery that has been made public. I saw, oh my goodness gracious. I saw the, stuff about the Snapchat stuff between him and Mariah, but I have not seen that. They said that was Instagram. It looked like Instagram messages, not like she posted it publicly, but like it was like the DMs and Instagram is what it looked like. Wow. So she doesn't want to testify. I think she don't want to be there. I'm not sure if the Instagram admission or message will be admissible. I don't know. I mean, this is going to be, they're going to continue to fight about this. Let me go back and read exactly what that said. Things just got interesting. Okay, it says, it says on June 5th of last year, she said, the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies. They didn't want us talking with prosecutors, but now they have all disappeared. I quit my job based on what Track and his wife or company said. Now look. And that's, of course, Melly's manager. She said, we can't go home. We're spending all my money I worked for, and they're taking trips and enjoying life. If you think I was a beast before, wait until this trial. I'm not holding anything back. I'm doing what I should have done in the beginning. They can call me Miss Snitch. This says, the next message says something about, I love Jamie and Melly, but he let his management team and lawyers F him over. Then the next message, they made me quit, told me that they would take care of us until trial is over. But guess what? Lies as usual. I was making $9,000 weekly. I didn't need anything from them, but everybody begging and pleading. Now they all ghost. I got something for Track, though. He lied to me and my child for the last time. Y'all can call me Miss Snitch because I'm airing him out to the prosecutor. I'm tired of him playing with people's lives. He messed with the wrong family. She didn't say messed. Wow. She said, right after that, she said, I haven't talked to her, but to get my freedom back and to go back to work, I'm ready now. Interesting. Track is the one, is Francois, Mr. Francois is what they were saying yesterday. That's the name of how he was on the I'm distracted by watching them laugh. Sorry. The car rental paper, the car was rented in his name. That's his manager. Oh, goodness gracious. I'm not sure who the other woman is either. What's somebody said that when that came up, when they were showing that I just reread, when it came up in court, he said that, let me not read it wrong, something about Melly was doing let me see exactly what he said so I don't read it wrong. Melly makes a facial expression as the prosecution reads a social media message from Holmes that said she will be a snitch when she testified after Track and Melly failed to support her financially. That's nuts. Let's see. I have not seen that. That was my first time seeing those messages. Let's see. True, she could be lying about what? Because they're not taking care of her. What is it that you think she might be lying about? Nope. They have not ruled on what's allowed yet. Now they're in recess. They're still going over all this. This testimony is the reason they're spending so much time fighting it. Defense does not want any of this stuff entered in. They don't want the jury to, and for good reason. It's very damning evidence against him. Like, having somebody who knows him, who saw him on FaceTime to say that, and those messages we just saw. I mean, think about our reaction when we just heard it. The jury would be the same way. So if that's admitted, then they will tell the jury, this is, evidence of them, going to pay her off in order to not talk to prosecution. Interesting. It's the first time I've ever seen messages for it entered into court. Or brought up in court, I should say.
I'd just like for the court to order this witness off the stand. I think the state has demonstrated that the only purpose for which they want that witness there is for the improper purpose, and they're compounding the prejudice by having her remain there. I think if the state has something that's admissible that they can prop to this court, that witness testimony needs to be concluded.
Thank you. They were spirit.
Judge, the state's not. There's additional information and things that's open to being talked about.
Thank you. So this is my thought, counsel. I don't have a problem declaring the witness to be hostile to the state and allowing you to ask leading questions. I'm okay with that. I think
That's been established. She's wearing an ankle monitor that was put on there by the state. I guess pursuant to this hearing where she was, I think you said she was in Islands.
Yes, sir.
Regardless, so I've allowed that. The problem I don't want to have happen, so we're clear, is I don't want you to regurgitate things that are in her statement that she's not, that doesn't comply with either of the two rules we've been going over. So I don't want you to be saying, well, didn't you say to, the police officer, Mr. Moretti, or whatever, the officer's name is Detective Moretti, that you saw them on FaceTime or whatever it was, that they were on that date when the incident in question happened, and Mr. Demons told you X, Y, and Z. All right? The witness hasn't subscribed that statement was accurate, so it's not getting in under recorded recollection, and it's not getting in as impeachment because it's not. It's a police investigation, not a deposition testimony or something along those lines. So it doesn't get in the way I read the rule under either of those two sections.
So
I don't want you to get in the back door, which you can't get in the front door.
No, just to make it clear, is Your Honor holding or stating that a police report cannot be used to impeach someone?
No,
Or,
I didn't say that. What I said was the statements in the police report, right? You can't just have that, read that back to her. Didn't you say this to the police officer? I don't want that being done. I don't think that's appropriate. She says she doesn't remember the statement, doesn't know it's accurate. She didn't rely on its accuracy. And
understood. And I just want to make sure it's also clear, under 9803 sub 5, the past recollections reported, there's no requirement in any of the case law or statute that the statement be sworn on that. If you look at that, because if there's other statements this witness has made that she may endorse as being truthful and accurate, and I'll have to ask her on that, then those are possibility of other ones that could be put in.
Your Honor, among the statements that we would like the court to forbid the state from asking in a leading fashion are the phone numbers or anything that she said to the officer on the day in question. What's the date that statement was made?
December 12th, 2018.
Nothing from that statement should be.
she'll ask whatever question she thinks appropriate. You make your objections, but I don't think it's appropriate to be asking, didn't you say this, X, Y, and Z. I don't think that's appropriate because she's not subscribing that this is what she, that statement is truthful, so I don't want you to just be regurgitating the statement and asking her that. I don't want that done, and I don't want you to do, anyway, we'll see where it goes.
Yeah, just one thing, Your Honor, I'm sorry to belabor the point, but I want to make sure that the state doesn't confuse the court's ruling to be one of form over substance, and instead of saying, didn't you say this, say, isn't it true that, or anything where the contents of that report are uttered out of her mouth that she knows this witness had not adopted, and she's gonna get a no, and she's just putting it into the record. It's improper. And
Hopefully I made myself clear, but that's why she's going to be able to, counsel's going to be able to ask whatever questions she deems appropriate. You make the appropriate objection if you think it's objectionable. I'm just going to rule her to go forward like that. I don't know what you intend to ask, counsel. I just don't want the contents of that statement, regurgitation of that in some form of leading questions, all right? All right, bring the jury in. Let's get the witness back in.
Okay, so she's now able to lead because she said when they asked her again about, like if I show you this video, will it remind, or audio, will it remind you of what you said? And she said, no, obviously that shows that she's not willing to be truthful. So they are able to treat her as a hostile witness, which means they can ask leading questions like they do when you're on cross-examination. So by doing that, she basically gets to, say, like he was saying, isn't it true that, this happened. So she's getting to lead questions based on her deposition. But she can't just open the deposition and read it.
Thank you.
I'm sorry.
So all this stuff that's about to either get said or not get said is going to be really important. She can't plead the fifth because she's not the one on trial.
Jury entering.
Please be seated. Let everyone see and reflect the presence for a jury. This is part of the City Council, the Assistant Attorneys, ladies and gentlemen, jury, and our witnesses home for me to understand. Apologize for the delay. Council, ready to proceed?
Yes, sir.
Please.
Okay, Ms. Holmes, when we left off, we were talking about a pet snake.
Yes,
Do you remember there being a pet snake?
I remember you talking to me about it yesterday.
Okay. And with regards to that snake, you recall it unfortunately passed away.
I'm pretty sure probably, I'm not sure it's not here, I'm pretty sure.
Do you remember the name of that pet snake?
No, I don't.
And in terms of the owners of that snake, do you remember who owned it?
I just know it was, I know who the owner was, it was in the house with Mariah.
Where did Mariah live at that time?
She lived in BMR.
And do you know the address?
No, I don't.
Who did she live with?
She lived with a boyfriend, but you know.
Are you telling the ladies and gentlemen of this jury that you don't remember your phone number and
I'm telling you guys, I do not remember my phone number. I don't remember.
And are you telling the ladies and gentlemen of this jury that you don't remember your daughter's phone number?
No, I do not remember my daughter's phone number.
And there's nothing that would refresh your memory or recollection whatsoever?
Objection, asked and answered.
Overruled.
That was 4 years ago. I've had so much trauma in my life since then.
Of course. So, is it fair to say that you were worried about Melly when you came down here to Fort Lauderdale on October 26, 2018?
Was I worried about him? Yes, I was.
You were worried about him because he had just been involved in a drug fight?
No, because they said his friend had been in a drug fight.
Okay. And you were worried about him because he was hiding in some bushes?
Objection.
I don't remember him in bushes.
What do you remember?
I sustain the objection.
What do you remember?
I just remember him saying for us to come get him.
When you made contact with him later that same day at Frito's house?
Yeah.
Is it fair to say he had no blood on him?
No, he didn't have any blood.
And is it fair to say that he left Frito's house and went up to a video shoot that afternoon evening?
Yes, I did.
Did you go to that video shoot?
No, I didn't.
Did Mariah live with Mr. Dennis after the homicide for a period of time?
Yes, she did.
Did she live in a condo in Miami with him?
Yes, she did.
Okay. made other statements about the events of October 26th of 2018.
I don't remember making any other statements.
Do you recall a Instagram conversation with the co-defendant Cortland Henry?
I don't remember it.
Okay, if I may approach.
Oh my gosh,
See if
is that who
refreshes
those,
your recollection as to that conversation?
is that who those messages were to?
It's 3 pages.
Is it from Mark Council?
Not yet, Your Honor.
I don't remember it. I don't remember it.
You don't have any recollection of that?
I don't remember it.
Is that your Instagram, Lane Queen 258?
Yes, it is.
Okay, and the conversation that you don't recall on that whatsoever?
Yeah, I don't remember it.
Okay.
Portland, the
Is
driver.
your testimony here today that you lied in those statements?
That I lied in my statements.
The allegations that you made to Mr. Henry?
I don't make those allegations, so I don't.
Do you remember sending screenshots of those allegations to a detective?
I remember sending a detective something stating that I didn't threaten Portland.
No.
Because I remember that.
You remember sending screenshots of conversations?
I remember telling him that I did, because he reached out to me and asked me that I threatened to kill Portland. And I said, no, I did not threaten Portland. I remember that.
Was there any threats made to you by the defendant?
No.
In terms of your daughter, Mariah, where is she?
I don't know.
After this incident, did she live with the family of the defendant?
She's always lived down there. Before this incident, she always lived there.
And your testimony to the ladies and gentlemen of the jury here today that you saw Jamell Demons October 26th, 2018.
Yeah, I saw him.
That you spoke with him and heard him on the FaceTime conversation.
I did speak to him, yes.
And it's your testimony that he indicated that it was some sort of shooting that occurred.
Yes, I did, yes.
Okay, and it's your testimony that you saw him on your daughter's cell phone as a video call.
I saw him.
Is it your testimony today that after that you called Jamie King?
Yes, I did call Jamie.
And in terms of the conversation with Jamie King, that occurred immediately after the FaceTime?
Not probably immediately, but sometime after. I'm not quite sure the time. I don't remember what time it was.
Okay. And it's your testimony to the ladies and gentlemen of the jury today that you were dishonest in your first statement?
I don't remember my first statement.
Okay. Is it your testimony to the ladies and gentlemen of the jury that you would lie?
I don't remember my first statement. I have no reason why you.
Yes or no? Did you lie to police?
I did not lie to you. No.
Yes or no? Did you lie to police?
I didn't lie to you. I don't remember my first statement. You're trying to make me say I remember my first statement. I didn't. For me to say no, I didn't lie with me. I remember my first statement. I don't remember it, so I don't remember.
Well, if you need more time to look it over, I have a copy of it.
I looked it over. I still don't remember it.
Okay. Well,
I did it over 100 times. I don't remember.
Well, if you'd be so kind as to do it one more time.
Yeah, sure.
You can say that to this jury that this is not truthful.
Yes.
Please.
Objection asked and answered 5 times, Judge.
Take objection noted. Move.
Lady Gray, hello, welcome. Upgraded membership.
Yeah, I honestly God do not remember any of this on here. Like, I don't remember talking. I don't remember. I had a hard time that year, so it's a lot that I don't remember about that year.
Is it your practice to lie to law enforcement?
Objection.
Excuse me, can I see
I've never told law enforcement.
Quiet, please.
Wow. me not let it blow my ears out. I shove it in there trying to eavesdrop, and then my ears get blown out when they come back.
So Ms. Thompson, is it the transcript that you're saying is on that?
Sustained.
I don't know.
Excuse me, sustained objection.
Okay, so going back to the relationship with your daughter and defendant.
Yes.
How long did that last?
3 years, I'm not quite sure how.
Okay. During the course of that relationship, did she have multiple photographs of him?
I'm pretty sure she did.
Videos?
I'm pretty sure she did.
After this incident, on October 26, 2018, at Frida's house, is it your testimony that your daughter went upstairs with Mr. Dennings?
She did. They did go upstairs.
They went upstairs. And do you know about what time you got to Broward County?
I probably got to Broward, maybe, I can't really remember the time, maybe, I don't know, but 1 o'clock, it was after lunch, because we went to right after. So it was lunchtime, it was 1 o'clock.
Do you remember going to lunch?
Yes.
Do you remember where you went to lunch?
I don't remember which restaurant.
Do you remember who you went with?
My daughter and AA.
And that's James Francois' wife?
Yes.
And do you remember, your testimony to the jury, that you remember the defendant, how he was dressed without blood on his clothing?
I don't remember exactly what he had on, but I just remember that there was no blood, because that would have freaked me out. So I know he had blood on.
No blood on him. Is it your testimony to this jury in terms of that you went to Frito Bang or Frederick Gibbons' house?
Yes.
No. Is it your testimony to the jury that there were other individuals present at that house?
Yes.
Who was it?
I don't know.
Do you recognize any of the individuals?
No, I don't.
Okay. Your daughter, she was present?
Yes, she was.
And in terms of your appearance here today,
yes.
You don't want to be here.
You might want to. You made on here.
I did.
Yes, you
So,
did.
and in terms of you were served with a subpoena
Never served.
and so you were ordered by the court to show up.
You never served me originally. That was a lie.
And in terms of your job,
Yes.
did you quit your job?
I got fired because you put me in jail.
And prior to that,
Yes.
before you were put in jail, did you quit your job?
No.
Okay, so you never quit your job.
I had to leave because you told my lawyer to put a warrant out for me. So I had to leave my job.
Okay, so you left your job.
Yes.
Did the defendant ever offer to pay for you and your daughter?
No, I did my own way.
Have you ever made things contrary to that?
I don't remember.
So I may approach her?
Your Honor, objection.
Just show counsel.
Sure.
Can we approach?
Sure.
Ah.
Are you done with that?
Man, I thought they were going to forget to turn the white noise on. So this is going interesting. The way they stopped to fight through it all, she's going to be on the stand as long as the gun guy was. So now she's saying that what she said in the Instagram DMs about how she's already left her job and they were going to take care of her and stuff. Now she's saying that the reason she left her job is because of the state putting out a warrant for her because she wouldn't go in to do her deposition. She's trying to avoid doing her deposition. And they needed her to come in. She wouldn't. So every time they would try to get her in, every time they would try to schedule it, she wouldn't. So finally, they put out a warrant for her in order to make her come do it. So they put out the warrant. She got arrested, and then she gave her deposition. Now she's got, because she wouldn't come in before and they had to put out a warrant to get her in, she's considered like a flight risk, I guess. So they put an ankle monitor on her too, so that she came here. Remember when we watched Travis Rudolph and Tyler kind of did the same thing? He didn't want to go the first time, and it was a problem, and then he didn't show up this time, and they put out a bench warrant for him. It's kind of the same thing. When you're subpoenaed to come be a witness, you don't really get to just say, no, I'm good. I'm really interested. I wish the cameras would have been on him when that happened. They said that when those messages were put up, that Melly was like, shh. Interesting. I'm going to pull up what the newest tweets are while they're on yet another sidebar. Do we know how many sidebars these are now? Nothing else really. We haven't missed any other tweets. The only other things he's tweeted right now are the things that we've seen. Nothing behind the scenes yet. Yeah, he does that a lot. He'll bob his head to music.
Okay. Ms. Holmes, were you ever told the defense, or the defendant rather, would take care of you and pay for your bills?
No.
Have you ever made a statement that is different than that?
Never say anything like that.
Can I approach that?
Sure. Just read this. I don't remember that.
Okay.
My bills.
So, Ms. Holmes, is it your statement testimony that you never stated the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies? They didn't want us talking with prosecutors, but now they've all disappeared. You've never said that before.
I don't remember saying anything like that.
Objection, Your Honor. Move for mistrial.
Thank you. Why don't you go sidewalk?
Oh! Thank you, JJ. He just moved for mistrial.
Ms. Holmes, did you ever say the defendant made you quit your job?
I never say anything like that. I don't ever made me quit my job.
Objection.
If I may approach him? Next few minutes. Okay. So I'm going to ask you again, have you ever made a statement that the defendant made you quit your job, that they would take care of us until the trial was over?
I never say anything like that.
Okay. So you're denying making that statement?
I never say anything like that.
Oh.
Objection. Your Honor, can I just have a standing objection so we don't keep interrupting?
Any, stay with you heard on standing objection?
Whatever defense
That's
chooses to
fine. Go
proceed. Okay.
No.
So, Ms. Holmes, in terms of
What?
a statement to the effect
No.
of you were told to quit your job and the defense would take care of us.
Of the judge? No.
Excuse me.
The defense? No.
Why don't you come sidewalk?
And we have another motion.
Oh my goodness. They're mad. They're only allowed to ask Melly questions if he decides to take the stand, which there ain't no chance he's going to take the stand.
Ladies and gentlemen, there was an objection made to the last question. I made a determination that was an inappropriate, improper question, and the way it's phrased was totally improper, and therefore I sustain the objection. I am instructing you that you will disregard the question. All right? I'm going to ask counsel to rephrase the question. Go ahead.
So it's clear. Ms. Holmes, did the defendant ever make you a promise to quit your job and that they had us?
Objection. Asked and answered.
Thank you. Overruled. Proceed.
I don't remember saying anything like that.
So your testimony is that you've never said that.
Objection. I don't remember.
Excuse me, counsel. She answered the question. All right? Let's move on.
So with regards to your statements with Portland Henry, do you remember speaking and talking about your daughter with Portland Henry?
No, I don't. When was that? I don't remember.
Sure. When was that? Here, I'll give it to you again. This was February 5th of 2021. You still have to?
Oh, no, I don't remember that.
You don't remember that?
Yeah.
Did you talk to Portland Henry about your daughter's involvement in this case?
Not that I can recall.
Ms. Holmes? Did your daughter tell you what happened in this case?
Objection.
What's the objection?
Calls for hearsay. It's immaterial.
Not what the statement said, but did you say something about the case? It's overruled. Not what we said. Just, did you have a excuse me. Not what we said. Was there a conversation?
Was there a conversation that your daughter told you what happened in this case?
What do you mean what happened?
Did your daughter ever
She never told me. She hasn't. I asked my daughter, did she know anything about this case? And she said no.
Have you ever made a statement different than that?
Not that I can recall. No, I don't remember saying anything like that.
May I approach her?
Yes, ma'am.
We object.
Why don't you show it to counsel first?
Sure.
Can we approach?
Yes.
So,
Oh my gosh. The whole day they've been up there. This is like pulling teeth to get any answers or any information. This is crazy. She doesn't want to say, I mean, it's all her, but now she doesn't want to say that it's her. So she's just, but she can't deny it either. So she just keeps saying, I don't remember. But I mean, the jury ain't stupid. not one of us that probably believes that she really has forgotten everything. She don't want to answer.
Case with friends, learning no research, just leave no notepads on your chair.
This is crazy. So she can't plead the fifth on. So like the Fifth Amendment is like you. It's about not having to be compelled to, in a criminal case, to be a witness against yourself, not against other people.
Want to come sidebar again, please?
The sidebar. Yeah, they're those statements they just read. I mean, now that's on the record, because she read them out loud. I wish I could read lips. What? YNW Melly. He literally just sniffed himself again. I can't hear them. All I can hear is whispering in the, or not like whispering, it's just really quiet talking. But more, oh, that's gone now. I was going to say more white noise than anything. And then they bust my eardrums. See, I need to know what they're saying. Is that a wig? What is that? What did she just pick up? Am I seeing things? Wait, that can't be a wig. Oh, it's a scarf. Okay. Okay. Carry on. It looked like a wig when she picked it up. I guess my old lady glasses aren't strong enough. This trial keeps getting weirder and weirder. Oh. I don't know where the girlfriend is, if she's there or not. I have not heard. Because he got a different one now, doesn't he? I could be wrong. I'm trying to read what he's saying with his lips. This trial is set. I think they've got time on the docket set until like August 2nd or 3rd. And they've got, they were talking yesterday and said that they believe prosecution is going to be done by July 10th. Defense said they'll be done with witnesses by July 19th, but the docket is right now set for, well, last time I checked, like August 2nd or August 3rd, something like that. Let's see. The daughter is also on the list. However, if this is happening with Mama, then it would not surprise me if the same thing happened with Mariah and her testimony and her wanting to testify. I'm not sure the lady at the table with him. I don't know her name. JT's playing us some music to set the mood. They are wow. I read that he hold on. Who's that? He's sniffing again. Look. And then he looks at the camera. What is happening? I don't even know, like, this is not normal behavior. I don't even know what I'm watching.
It looks like the person who was done this council is assistant attorneys. The jury's not here. They're adjourned. So we all ready to proceed?
Yes.
All right. See if they're here, please. See if they're ready.
They're bringing the jury back in now. Kathy says 3.
Jury entry?
3 minutes.
Thank you. Let the record reflect the presence of the defendant, his counsel, the assistant state attorneys, ladies and gentlemen of the jury, our witness remains on the stand. Please be seated. And remind you, Ms. Holmes is still on the road. Counsel, please continue.
Let me let me come back and ask you, did your daughter tell you, did you have a conversation with your daughter about what happened on October 26th of 2018?
Yes, I asked her if she knew anything about that.
Did she tell you what happened without? No, she did
Just
not.
told she didn't know.
Have you ever made a statement that is different than that?
Your Honor, we'd object to lack of foundation, calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. The objection noted. That's what I previously ruled on sidebar. Proceed. To your approach.
Showing me your messages from Instagram from February 5th, 2021.
Who was that Instagram? Is that the one, this memory stands with Portland?
Ma'am,
I don't
sorry.
remember that Instagram.
Look at it.
I already looked at it, you're gonna show it to me.
So is the.
I don't remember that, you showed it to me like 3 times already.
So you don't recall making
I don't
a
recall
statement?
making a statement, no.
Excuse me, one at a time, please. Let her finish her answer before you ask the next question.
So you don't recall making that statement?
No, I don't.
So you don't recall saying,
Objection.
Sustained.
so, Ms. Holmes, in terms, you said that your daughter didn't tell you.
Objection, asked and answered.
Sustained.
So did you ever make a statement that's different than that?
Objection, asked and answered.
Sustained.
Into the statements that, with regards to October 26th of 2018. Is it your testimony to the jury that you remember coming to Fort Lauderdale?
Objection, asked and answered.
Sustained. Listen, I just want one of you making objections. Whoever's going to handle the
Yes,
witness. All right?
I apologize.
Ms. Holmes, is it your testimony you don't remember why you came down?
I told you why I came down.
Okay, why is that?
Objection, asked and answered.
Sustained.
Ms. Holmes, have you ever let me rephrase. Ms. Holmes, did your daughter ever threaten to cooperate with law enforcement?
Objection.
Sustained.
Ms. Holmes, did you threaten to cooperate with law enforcement?
Objection. Asked and answered.
Different question.
Why don't you come sidewalk? I want to see the question, please.
Oh my God, the sidebars. They're doing everything that they can to get this into evidence and on the record. So all the stuff that we just heard in the messages where she said that since they're not paying for her stuff like they said they were going to, that she is going to snitch, or they can call her Miss Snitch and all that. She's saying she doesn't remember any of that now.
Ms. Holmes, did you ever make any statements about what happened on October 26th of 2018?
Objection. Asked and answered.
I don't know what statement you're talking about. Rephrase your question to specific.
Ms. Holmes, did you ever make any statements specific to what was happening in the car on October 26th of 2018 prior to the homicide?
Objection.
Thank you. I still come on sidewalk, please.
Oh my God. I would be frustrated if I were the prosecution to have her say these things on record under oath.
So, Ms.
Under oath.
Holmes, I want to ask,
And then get to trial and
were you present when your daughter spoke with law enforcement?
She was 17, I had been present.
Do you recall about when that happened?
If she was 17, that had to happen in 2018.
Okay. Without getting into what she said on that. Do you remember where that statement was taken?
No.
When you came down to Fort Lauderdale, was your daughter concerned for Mr. Dennis?
Objection. Cause for conclusion on part of this witness.
Based on your daughter's demeanor, how was she acting?
Sustained.
When you arrived in Fort Lauderdale and saw Mr. Dennis, did you ask him what happened?
Objection. Asked and answered.
subjecting to everything.
I'm sorry, repeat the question?
When you arrived in Fort Lauderdale, did you ask Mr. Dennis what had happened?
No, I did not.
Nothing further.
I have one question.
Yes, sir.
You came here and one of your first, let me get it.
Objection, Your Honor, improper.
I haven't asked you.
Excuse me, Counsel, you direct your comments to.
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, "I feel threatened."
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
What the rules?
Christine Brandi, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Anything else in this witness?
Yes, Your Honor.
Oh, this is getting bad.
Ms. Holmes, you said you feel threatened by me.
Of course.
Okay. Did you fail to appear for numerous court appearances?
No, I never served me, lied.
Okay.
Lied to the court.
And with regards to, did you work in Redding, California?
Yes, I did.
Okay.
Terrible rules.
And so that was a location you were at?
That's why I was traveling or something.
Okay. And in terms of the prosecution, you have been served on various occasions to testify.
You served me a subpoena on November to be the next weekend. I was in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in February of 2019.
You never served me. I know you served me to a location I didn't live at anymore.
Do you recall coming to the courthouse in February of 2019?
Objection beyond the scope.
Excuse me.
Anything about the courthouse tonight.
Excuse me, come sidebar.
Sidebar. Oh. Oh my gosh. She remembers those details. The thing is, there's nothing on the stand that she said now that's credible.
So, Ms. Holmes, you even went so far as to hire an attorney to try not to show up.
I sure did.
And has the state offered you any money?
The state basically has me on a monitor. I have to go to my job with this. It's embarrassing. People think I'm a criminal. The state had to run my life.
And in terms of your feelings and ill will towards the state and myself,
I just feel like you lock up innocent people.
and does that influence your testimony today?
It's not influencing my testimony.
Have
No,
you-
I'm telling you.
Have you- that's not-
Excuse me, hold on. Only one of you can talk at a time. You ask the question, counsel, you answer it, and when you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, Your Honor. So the my question was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued,
Yes.
you're aware that that was found to be valid?
No, I'm not aware of that at all.
Okay. You hired an attorney to go and represent you with the Fourth District Court of Appeals?
He had to hire an attorney because you tried to get him this far.
And that's a false statement.
Objection.
Excuse me. Counsel, you're not testifying.
I
all right?
agree on
You
that.
excuse me, you asked a question, all right? That's it, you asked the question.
And so, Ms. Holmes, with regards to that, you hired an attorney
Yes.
and you then tried to get any sort of court order requiring you to be here in court thrown out.
No, what I did was I hired an attorney because you were saying you served me the subpoena that you never served.
And that was found to be valid.
You never served me a subpoena that was you never served me.
Oh.
I've never seen a subpoena from you from those addresses that you said you served. Those
So-
are not my addresses.
Your testimony is that you have never been served to appear in court.
Objection, asked and answered.
Sustain. Excuse me, sustain.
And so, with regards to your feeling threatened on that, have I ever, any sort of physical violence against you?
No,
Do you have any written threats from me?
it's intimidating. You've intimidated me this whole time. As of
And,
now,
and in terms of your participation in this case,
yes.
you understand that you were served a subpoena to appear here today?
You served a subpoena after you arrested me. You
And you,
served a subpoena at the jail when I
and
was
you
in
have-
Broward County.
and you understand you're here pursuant to that court order?
I'm here.
And that requires, under the law, to comply with court orders to, and that compel attendance of witnesses.
I've been complying.
Nothing further.
Anything further?
No, sir.
Thank you. This witness excused.
Yes, Your Honor.
Thank you, ma'am. You may step down, you're excused. Want to come sidebar here, please?
Sure.
Looked like he was watching her walk out. Oh.
Hey, Jonas. just checking with council, that's all the evidence we have today. So my thought is, remember the admonition, we'll see you back on Monday though, 9 o'clock. Remember, do not discuss the case. Tuesday, that's right, Monday's a holiday, thank you. So Tuesday at 9, don't discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence, certainly no research, all right? Same admonition I give you every time we break. We're counting on you to follow it. All right, just leave your notepad on your chair. We'll see you back on Tuesday, 9 a.m. Thank you.
Yeah, they're in and early today. They said that's all the evidence that they have ready for today.
What good evidence?
I don't know.
Let the record reflect the jury stepped down. Counsel remain along with the defendant and the assistant state attorney. Ms. Brandi, my clerk is advising me that I don't know if it was, I don't think there's any evidence that she had something that might have been marked as an exhibit.
It was not marked, Your Honor, it was just a copy of the
So
transcript.
you're okay with it?
Yes, Your Honor, I have plenty of copies.
All right. In any event, so jury's been excused, counsel remain along with the defense, so you have a couple motions from Ms. Bryan. You want to talk about those?
Yes, sir. As sure as I could predict that Tuesday comes after Monday, I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that that was what the state intended to do it, advanced a ruse pretext that they were seeking to do so under 8035. It turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to plan one, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had, into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially tried to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Demons has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate. It is highly prejudicial. This jury has been tainted, and we move for a mistrial. Oh, there's one more thing. If you don't mind, I'll have Mr. Alistine articulate what that means.
This is your motion for Mr. Travis?
Yes, it's our motion for mistrial.
This is the second one. All right, go ahead.
Well, second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness. And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, your Honor's instruction to ignore it, it's pretty hard to ignore something like that when their entire questioning for the last 30, 40 minutes have been so improper and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text, couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since, so just to let the court know there is no factual predicate for the implication, or not implication, the accusation made by the state that the defense sought to take care of her.
And the same for me. I met her at the depot and saw her today.
For the record, it was my first time ever seeing her in my life.
Thank you. All done, guys? Counsel?
Yes.
Yes, madam?
Judge, with regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not intended in any way, shape, or form. I was basing it based in the records and the statements that this witness made and put forth in her Instagram account about this case on that. And it's very, in terms of the forming the questions, Your Honor, it was understood that I was put under very strict and difficult conditions to formulate any question, because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their client. Hence why the state would be seeking to use her as a witness.
That means nothing, Your Honor. The fact that it's damaging, I'll concede that. It's inadmissible. And the statements of this impression that there is a catch-all, we're only trying to seek justice and do good exceptions to all the rules of evidence, and there is no such thing. If it's admissible, admit it through an admissible procedure. You don't try and end around the court's order and the case law by coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced. Or that Mr. Demon's interests have been irreparably prejudiced before this jury.
Thank you. In any event, I'm gonna defer ruling, take it under advisement. We'll see everybody back on Tuesday. I suggest that you talk with your client, discuss with Mr. Demons whether or not his feelings about motion for mistrial. I think it's appropriate that he be consulted as well. But I haven't reached any conclusion about it, and so I'm gonna see exactly what was said. I thought I heard what was said, and I'll check with the court reporter, get a little piece of that transcript, and we'll go from there. And I'll take it under advisement. But you talk to your client about it. We'll see everybody back on Tuesday. All right.
Yes, sir. Have a good weekend, sir. Judge, since we're breaking early today, can we have a few minutes with our client?
Sure, I'd like you to take a few minutes with him. I'd like you to talk it over with him.
Yes, sir.
Can we have the cameras off while we talk about it?
I can't hear you.
The camera's off.
Oh, you want privacy? That's fine. The cameras can be excused. They can go out of the courtroom.
Thank you.
But everybody can go out of the courtroom. All right?
Thank you so
Thank
much.
you, Juror. This is like a private conference area.
Thank you.
Well, they're kicking us out. So that was all interesting. So he's going to look at everything over the weekend and decide, take it in consideration what they're saying and decide on his motion for mistrial. So what a freaking day. Okay, so they are wanting to, they're wanting to do mistrial and start the whole process over again. I seriously doubt they're going to grant that. You know, it took them from like April, I think is when they started doing jury selection. So if they did a mistrial, then in order to, because it's a death penalty case. So if they did a mistrial, then they would have to start over, and it would be a huge, huge moment. Hi, pretty girl. Because then they're literally starting all over again. Interesting. So it's crazy how split our poll is. 53% say that right now they're leaning toward guilty. 16% say not guilty, and 31% say undecided. So that's where we're at for now. So court, I'm going to end the poll. Court is done for the day, and we are out of court tomorrow. We are out of court Monday. What I'm going to do is sleep in, number one. No more early mornings tomorrow. Tomorrow, I'm going to get together some of the, that one little 10-minute video I did. I started getting some stuff together to go over like a little bit more in depth, everything that we've been given so far. So I'll probably work on finishing that this evening for a little bit, since we're off early, and then maybe some tomorrow, and I'll probably stream tomorrow afternoon. Basically what it is I'm going to go witness by witness and break down just a quick summary of the important stuff and like between the witnesses and the evidence that we've got so far. So we'll go over that, and we'll do it as just a short live stream. I know that some of this stuff was so boring, like the boring foundational stuff. And then some of it, you know, people were saying that they were having a hard time getting into this when it first started. So there's some stuff that was probably missed. So we'll do a little recap stream of the first 4 days, where I'll have the pictures and the graphics and all that stuff that I do. And we'll go over everything that we've missed so far, because there are some things that, you know, it's easy to miss while things are going through. So we'll do that. And then we have a long weekend. Yeah, I think I've had it so many people. I know that like this one is one that it has been hard for people to. I'm good. Thank you. Just offering me more snacks. I know that this has been one that people have had a hard time getting into some of the witnesses and stuff. So I think, and I know that there's a lot of information and it's hard to hear data and understand what it means. So that's where the graphs and all of that come in. So let's see. Let's see. Mistrial will make everything so difficult. Yeah, mistrial would, to find a whole nother jury and a whole nother jury that's going to be, you know, death penalty qualified. The stream is going to be probably, we'll probably do it maybe after lunch. Or maybe I'll do it before so then I can spend the rest of the day at the beach. It's not going to be real early though. It'll probably be maybe closer to 10 or 11. All right. So I will, whatever time we decide, I'll post it on YouTube to let y'all know. And then I'll post it on Twitter and on Facebook too. But it'll just be basically a quick breakdown of all the evidence and everything that we've seen so far, and the exhibits and the witnesses and all that, everything we've seen so far. All right, y'all, I appreciate, I have no idea why they're not doing court tomorrow. I know we're not doing it Monday, but I don't know why we're not doing it tomorrow, but I'm okay with it. All right, I've been sitting on the floor because this chair is not the most comfortable. This is the last day streaming at my mama's. I get to be back to my own place tomorrow. Thank goodness. So let's see. I'm going to get some clips together of that too. I've got a few things that I'm going to get together that I've been working on. I was planning on just doing it Monday, but since we didn't have court, but I think I'm going to go ahead and do it tomorrow. But I've got some clips and some stuff that we're going to look at. All right, y'all, I am going to get up off this floor and go relax for a little bit. And then I will finish that video. And I'll put out when it's going to be. I appreciate y'all hanging out with us today. We had a good crowd in here. I can also, if you have any questions, I've been trying to answer questions as we go, but I've got a bunch of the court docs too. So if you have any questions about anything that you want, if you email them to me, I'll try to make sure that if like there's any a part of the trial that you're confused about is what I mean. Like, or if there's any part you want clarification on or want to see broke down or anything like that, email it to me and I'll see if I can make sure that we've got it on the video. So, all right, y'all, I appreciate everything. I appreciate y'all showing up for jury duty, and I will see y'all tomorrow.